morning and a warm welcome to everyone to this workshop on environment, human rights and business. It's an event which is being organized by the Steering Committee for Human Rights under the German presidency of the Committee of Ministers of the Council of Europe. We have around 190 registered participants. We view some of them in the online platform right now. I don't think everyone has connected yet, but hopefully more participants will connect shortly as we progress in our workshop. There will be 3 sessions in this workshop. The first is seeking to explore the nexus between human rights and business responsibilities to protect the environment, how this nexus can be found in international human rights law. The second session will center on effective remedies for victims of human rights violations in relation to business and the environment. And the third session will seek to explore the role of the Council of Europe in promoting business environmental responsibility. Without further explanations on the session, we will have plenty of time to discuss during the sessions. I will just try to give some housekeeping indications. We are having this event on the Kudo platform. It's an online platform. The panelists, the speakers, and the moderators will have their time slots to make their interventions, to provide their inputs. And then there is a short time foreseen for Q&A, for discussion after those interventions. You will be able to ask for the floor through the Kudo platform, so please do that, or to send your questions via the messaging function of the Kudo platform. So please take a moment to familiarize yourself with these very basic and very friendly, user-friendly functions of the platform. The event will also be live streamed on the Council of Europe website on the news item. You will have received the news item via email that was sent yesterday. So that will give you a link to the live streaming of this event. Without further ado, without further remarks on my side, I will now like to give the floor to Mr. Christophe Poirel, who is the Director of Human Rights in the DG1 in the Council of Europe, to be followed by Ms. Sigrid Jacobi, who is the representative of the German federal government for matters relating to human rights. So, Christophe, you have the floor, please.
First of all, good morning to all participants. I was very pleased to hear you announcing the quite high number of participants that will follow the workshop this morning, Elvana, and I think it is very good, first of all, and very promising. I would like to start at the outset by congratulating and thanking the German presidency of the Committee of Ministers of the Council of Europe for organizing this workshop together with our Steering Committee for Human Rights. This event is obviously very timely, as the issue of environmental protection is high on the agenda of all governments in Europe and beyond. I would just refer to the renewed commitments that were announced by many states a few days ago on the occasion of the Earth Day on 22 April. The Council of Europe itself has engaged with the issue of human rights and business, not just last week on the 22nd of April, but for a number of years now. the most important instrument from the perspective of the Council of Europe is, of course, the European Convention on Human Rights. The European Court of Human Rights has affirmed in its case law that state parties to the Convention have positive obligations to prevent and address violations of the rights of individuals inflicted by private persons and entities. So this is our, in a way, our doctrinal foundation, I would say, of responsibilities of business with regard to human rights. As you announced, Elvana, just now, there will be a first panel on the international framework and the convention in particular. Our court, I must say, itself organized a major conference, and quite an interesting conference, almost 1 year ago, where there was already quite an interesting and substantial discussion on the state of the case law of the court. I would say perhaps also the limits of the existing case law, but I'm sure the first panel will be very interesting in that respect. Beyond the Human Rights Convention, there are other Council of Europe instruments that are relevant, and I would like to mention one of them, which is the 1998 Convention on the Protection of the Environment through Criminal Law, which is another convention which, to an extent, is relevant with respect to businesses, companies, enterprises. Our European Committee for Crime Problems, the so-called CDPC, has decided to engage into an exercise whereby this committee is going to have a fresh look at the 1998 convention and see to what extent the convention needs to be modernized, or whether even a new convention should be prepared. There was a first meeting of a working group of the CDPC last week, so that is an additional instrument that needs to be mentioned. When we come to non-binding instruments of the Council of Europe, because we have conventions, but we have also non-binding instruments in the form of recommendations, I would like to mention in particular the 2016 Committee of Ministers recommendation providing guidance to our member states on how to implement the UN guiding principles on business and human rights. Since then, we have organized numerous awareness raising and training activities on the recommendation. And I would like to mention in particular the online platform on business and human rights, which we have developed and which you can access through the Council of Europe portal, this dedicated webpage of the Steering Committee for Human Rights. And on that online platform, you can have a comprehensive overview of our action. Following this recommendation, we had a conference on environmental protection and human rights that was organized by the Georgian Chairmanship of the Committee of Ministers in February of last year, which gave, I must say, a new impetus to our engagement with the issues that we will be discussing today. Later on, the Joint Declaration on Human Rights and the Environment that was adopted on 15 May 2020 by the outgoing Georgian and incoming Greek and German presidencies of the Committee of Ministers of the Council of Europe set the pathway to the current work in the CDDH to elaborate a draft non-binding instrument on human rights and the environment. In the first meeting of the CDDH drafting group on human rights and the environment will start tomorrow. We have the pleasure to have with us today the chair of the working group, Christine Elichis, who will moderate the first session. And I think it's really, this event today is a good opportunity to bring food for thought for the future work of this drafting group. So no doubt that the workshop, as I said, will provide the ideas and to the experts that will take part in the work of this group, not least because of its specific angle, which is to explore how the framework on human rights and business can address environmental protection challenges. The question of environmental corporate social responsibility is gaining more and more attention in the context of the interpretation and application of the international principles on business and human rights. So, and we will hear more on this from the excellent speakers that we have invited today. And I would like to take this opportunity to thank them very warmly for having accepted our invitation. The workshop, as we all know, takes place in the context of a global sanitary crisis that has been unfolding for more than 1 year now. The crisis continues to put all states to test as regards their duties to secure human rights. As witnessed in all countries, I believe, the crisis unfortunately exacerbates social inequalities, and those already vulnerable in relation to employment and access to public services are likely to be even more at risk to lose their livelihoods and healthcare provisions. And I would like to mention at this juncture a statement that was issued in March by our European Committee on Social Rights, which is one of the two bodies which monitor the implementation of the European Social Charter, a very detailed statement which mentions many relevant provisions of the European Social Charter. But the crisis also continues to test the business's responsibilities to protect, respect, and remedy human rights, as companies of all sizes are now facing unprecedented and long-lasting challenges due to collapse in supply chains, disruption of production and trade. So economic recovery and addressing the social inequalities will require the concerted efforts of the private and public sectors, newer approaches, and perhaps even unconventional thinking. This time of a crisis provides important opportunities for states as the human rights duty bearers to incentivize companies to improve their social and environmental performance. It also provides opportunities for companies themselves to seek stronger operational efficiency and productivity by integrating environmental protection goals and tools into their strategies and day-to-day activities. I think the recovery of our economies once the pandemic is over should not be considered as a contradictory with the need to protect the environment. On the contrary, the two need to go hand in hand, and the post-COVID-19 phase, hopefully that will emerge in the coming months, should be used, as I said, as an opportunity to address and more efficiently environmental challenges from the point of view of businesses. The quick question remains whether we will seize these opportunities and consolidate a solid framework of environmental corporate social responsibility, which will translate into better protection of human rights and a more equitable and environmentally sustainable development. I think this is most probably, I would say, one of the major challenges that will be facing our societies, public authorities, in particular in Council of Europe member states in the years to come. So I very much hope that this workshop will provide stimulating reflections on this matter and also very important related issues that I have no time to mention just now. And with that, I would like to wish you all very fruitful discussions. Many thanks again to all participants, and a particular thank you to the speakers that have agreed to join us this morning. Thank you very much for your attention.
Thank you, Christoph, for your perspectives. Thank you very much. Now we will move to the next welcoming remarks by Ms. Sigrid Jacobi. Please, you have the floor.
Welcome to all of you from Berlin. Let me start by thanking all of you for tuning into today's workshop on environment, human rights, and business. This is no small feat given the countless numbers of web conferences that we are summoned to participate in these days. Let me also thank the outstanding speakers and participants that have accepted our invitation to discuss this timely subject. We look forward to hearing your insightful input and guidance. Our conference centers on the issue of environmental protection and human rights, not because this is new. In fact, it is not new at all. You will recall, for instance, that the Parliamentary Assembly has raised the issue of human rights and environment on various occasions since 1999. The CDDH Manual on Human Rights and the Environment sets out the interrelationship in detail. And there is extensive jurisprudence by the European Court of Human Rights. Today, the connection between human rights and the environment is thankfully a non-starter. What is less obvious, however, is whether and how we integrate business and state obligations into the equation. This is the issue we will address together today. Let me point out some core questions that we may set out to answer. First, how can the transformative potential of human rights be brought into environmental law? I believe that we should reflect upon and be mindful of the challenges involved when integrating international environmental law into the business and human rights agenda. Second, we can ask, how can states' positive obligations to protect the environment and relating rights be compared and distinguished from corporate responsibilities? Addressing these differences normatively may turn out to be quite tricky. Third, also, what are the specific limitations of state action when it comes to remedies for environmental damages related to business activities? Can alternative dispute resolution schemes provide relief for those who are affected? In this area, I think we will need to find ways to alleviate existing power asymmetries and incentivize rights holders to engage remedial mechanisms. And finally, what role should the Council of Europe as a human rights organization play in this field? I'm confident that our discussions will provide inspiration for meaningful developments in these areas. The Council of Europe provides a unique setting to engage one of the central issues of our time, cooperatively and constructively. In this spirit, I look forward to a fruitful discussion and wish you all a very interesting conference. Thank you very much.
Thank you very much, Madam Jacobi, for also raising those very interesting questions, which sets also the expectations about this workshop from the very beginning. And we look forward actually to discussing with experts those questions. Without further remarks on my side, I will now invite our moderator of the first session, Ms. Christina Licis, to take over the moderation of the first session of this workshop, which, as we mentioned, focuses on the international human rights law framework and how it encompasses the questions that we are trying to find some answers in this workshop. Christina, over to you.
Thank you. Good morning, everyone, and welcome to the first session of this workshop. My name is Christina Licis. I'm the government representative of Latvia before the European Court of Human Rights, but I'm here today in my other capacity. I'm the chair of the Council of Europe Drafting Group on Human Rights and Environment, which is the subsidiary body to the Steering Committee on Human Rights. And I'm very, very pleased and honored to be here and to moderate the first session of this workshop. As the title of this first session suggests, the task is to set the scene for the discussion. And in doing that, let me first of all recall some of the events, recent events that have contributed to the discussion on human rights and environment, and especially from the perspective of the Council of Europe. Mr. Poirier already mentioned that about a year ago, under the chairmanship of Georgia in the Committee of Ministers, we had a conference on relationship between human rights and protection environment. In this conference, we looked at the role of the Convention on Human Rights as well as the European Social Charter. And it was very clear throughout the conference that the already existing interpretation of these two instruments has clearly shown a link, a strong link between human rights and environmental protection, also underlining the obligation of the states to take proactive measures, the positive obligations of the states to protect the environment. So that is the first major event. And it was already mentioned that later last year, the three chairmanships of the Committee of Ministers adopted a declaration regarding environment and human rights. In light of these conclusions from the conference, the Steering Committee on Human Rights has indeed embarked on a process to draft non-binding instruments, the recommendation of the Committee of Ministers on human rights and environment. And I'm very pleased and honored to be the chair in the working group for this task. And indeed, our first meeting starts tomorrow. So today's workshop is very, very timely, as it will put us in the right frame of mind and also will give us food for thought during the discussions for the remainder of this week. Today, however, this workshop brings a new dimension to the discussion, namely the nexus between human rights and business responsibilities to protect environment. So we'll seek the answers to these questions of how the states and corporate responsibilities in terms of human rights and in terms of environment come together, and whether the human rights law can provide some answers in this regard. In particular, again, to help set the scene, we will look at the question of what guidance, what models the international framework on human rights and business, in particular the UN guiding principles on business and human rights, what these frameworks can provide us in terms of state and business enterprises' responsibilities to protect the environment. We'll look at the responsibilities of states to prevent and redress human rights violations, and we will also look at the corporate human rights due diligence standards and how they relate to the protection of environment. Again, I refer to the previous speakers who've already mentioned the Council of Europe recommendation on human rights and business that can provide inspiration in our discussions as well. We will also address specifically the interaction between human rights and environment in the jurisprudence of the European Court of Human Rights. And in this regard, I would also like to share a piece of information. The drafting group that will start its meeting tomorrow will have as its first task to update the existing manual on human rights and environments, which contains a very broad analysis and reflection on the existing case law of the European Court of Human Rights and also the Committee under the European Social Charter. So that will be another contribution to the increasingly dense network of instruments and sources. And in particular, this compilation will provide an updated look at the state of play of the case law at the court. In doing that, we have a pleasure of very good speakers and prominent scholars. Today, our keynote speaker for the first session is Professor Surya Deva, Associate Professor of the School of Law of the City University of Hong Kong, and also even more importantly for the purposes of today's seminar, Vice Chair of the UN Working Group on Business and Human Rights. We also have 3 panelists, Judge Lado Chanturia, judge from the European Court of Human Rights elected with respect to Georgia. I didn't see Judge Chanturia on the list of participants earlier. I hope he'll be able to join later. Another 2 panelists are Ms. Chiara Macci, postdoctoral researcher at Wageningen University, and Mr. Carlos Lopez, senior legal advisor at the International Commission of Jurists. Before I give floor to Professor Deva, some practical information regarding the organization of this session. The keynote speaker will have approximately 15 minutes for the presentation, and then each panelist will have about 5 minutes to present the key points of their consideration. Then we will have approximately 20 minutes for questions and answers. If you wish to put a question, you can either write a message in a Kudo platform in a chat area in the messaging part, or you can also ask for the floor, and I will give you the floor, and you can ask the question. I hope I'll be able to see all messages, and I hope my colleagues in Strasbourg and Berlin will help me if I miss any questions. So without further ado, Professor Deva, I'm ready to give you the floor. Please ask for the floor. My apologies. Could you once again press ask for the floor? Professor Deva, you have floor.
Thank you, Madam Moderator. It's really my great pleasure to be sharing some remarks on this important theme. At the outset, I would like to thank the Council of Europe's Steering Committee for Human Rights, as well as the German presidency of the Committee of Ministers for inviting the UN Working Group on Business and Human Rights to speak at this important workshop. Articulating the relationship between environment, human rights, and business, which is also the central theme of this workshop, will be a key issue in the 21st century. In my remarks today, I will approach this relationship from a business and human rights lens and share some thoughts on how to ensure inclusive and sustainable development. It is now well established that business enterprises have a responsibility to respect all human rights. The guiding principles on business and human rights, which were unanimously endorsed by the UN Human Rights Council in June 2011, played a major role in establishing this minimum floor. In the last 10 years, we have seen an impressive uptake of the guiding principles by all the stakeholders. So what guidance do the guiding principles provide us about the responsibility of businesses regarding the environment, including climate change? Although this may appear surprising, the guiding principles do not expressly mention environmental rights or climate change anywhere. This climate change blankness is not unique to the guiding principles. The OECD guidelines for multinational enterprises, another leading international standard in the business and human rights field, do not expressly deal with climate change, despite having a dedicated chapter on the environment. This does not, however, mean that businesses have no environmental responsibilities under these international standards. In fact, businesses will not be able to discharge their responsibility to respect human rights under the guiding principles unless they integrate environmental considerations into human rights due diligence and remediation processes. This is so because of inherent interlinkages between human rights and the environment, something which is reinforced by the framework principles on human rights and the environment developed by the former UN Special Rapporteur on the Environment, Professor John Knox. Moreover, the commentary to Guiding Principle 12 provides that businesses may need to consider additional standards depending on circumstances. Standards relating to the environment and climate change would be a suitable candidate for inclusion in such additional standards that businesses must consider as part of their minimum responsibility to respect human rights. Corporate integration of environmental considerations into human rights issues and legal regulations. Consumers, shareholders, and institutional investors are increasingly expecting companies to reduce their carbon footprints and disclose regularly information about measures taken or planned in this particular regard. In line with the guiding principles, these expectations extend not only to climate change caused by the companies, but also to climate change contributed to or directly linked to their products or services through their business relationships. The evolution of mandatory human rights due diligence laws in Europe is also pushing businesses to consider adverse impacts on both people and the planet in a holistic manner. The French duty of vigilance law expressly includes risk to environment as part of vigilance plans to be developed by covered big companies. The European Commission's proposal for a mandatory human rights and environmental due diligence law also points towards the need for businesses to identify, prevent, mitigate, and remediate impacts on both human rights and the environment. Moreover, climate change-related cases before courts and other non-judicial institutions are likely to push companies to consider climate change and environmental issues as part of human rights. Although human rights due diligence should be a critical tool to prevent adverse impacts on the environment and climate, we should not see this as a panacea. Human rights due diligence alone, even if mandatory, is unlikely to save the planet in my view. Additional, more transformative changes would be needed in the current economic order. One may need to ask whether the current model of economic growth and lifestyles is sustainable. In other words, whether we should go back to bikes or towards battery-operated vehicles. Moreover, both states and businesses should appreciate that due diligence in the climate change context may mean adopting different approaches, for instance, to identify impacts and consult relevant stakeholders. Although preventive steps on the part of businesses are critical, they are rarely foolproof. Access to remedy and corporate accountability should be an equally important component to the goal of protecting the environment. As the Working Group on Business and Human Rights highlighted in its 2017 report to the UN General Assembly, remedies, in order to be effective, should combine preventive, redressive, and deterrent elements. Moreover, remedial mechanisms for climate change would also need to consider and find innovative solutions to unique challenges posed by standing requirements, attribution, ascertaining contributions of different actors, and global dimensions of adverse impacts. In the closing, let me highlight 6 additional issues that we should consider, Madam Moderator. First, both the states and businesses should keep in mind that the impact of environmental pollution or climate change is not felt by all rights holders in the same way. Women and girls may, for example, are likely to experience differentiated and disproportionate impact of climate change. Therefore, it will be critical to adopt a gender-responsive approach in conducting human rights due diligence as well as providing remediation. The Working Group's 2019 report to the Human Rights Council provides useful practical guidance on how to do this in practice. Second, transition to green economy and climate change adaptation measures should also be human rights compatible. Otherwise, this would worsen the situation of vulnerable or marginalized individuals and communities. Third, environmental human rights defenders and climate activists have a central role to play in protecting the planet. However, they are facing increasing threats from many states and businesses. Defending these defenders from harassment, arbitrary arrest, unlawful detention, and at times killing would therefore be essential. Fourth, Coherence in corporate governance is another issue that we should pay greater attention. For example, companies which publicly claim to respect human rights and the environment should not be allowed to lobby governments in the dark to dilute environmental standards or delay plans to phase out fossil fuel. Businesses should also abandon policies and practices aimed at promoting unsustainable consumption as part of responsible business conduct. Fifth, although mandatory measures are essential, states would also need to provide incentives to encourage businesses to move towards a zero carbon economy. And I think that is where the smart mix of voluntary and binding regulations becomes relevant. They should also work towards achieving policy coherence. Trade and investment policies, for instance, should take cognizance of environmental and climate change considerations. Sixth and the last point, because of transnational dimensions, protecting the environment and mitigating climate change would require collective actions on the part of both states and businesses. International cooperation and partnerships would be essential, for instance, to ensure access to technologies needed to save the planet. I look forward to the discussion today. Thank you very much for the invitation and the kind attention once again. Back to you, Madam Moderator. Thank you very much.
Thank you, Professor Deva, and in particular, thank you for the very clear 6 points at the end of your statements. I think you, in these brief 6 points, you managed to cover the whole breadth of the issue, starting from protection of human rights defenders and ending with the need to balance incentives and perhaps punitive actions. I would ask the panelists and Professor Deva once again to ask for the floor, because if you push the button release mic, it actually removes you from the screen. So yes, Professor, I can add you now. And I also would like to ask Chiara Macci and Carlos Lopez to ask for the floor. Yes, so I can add you to the screen and give you the floor for further comments. Mr. Lopez, if you would ask for the floor so I can add you. While you do that, I'm happy to give the floor to Ms. Macci. I would add that Ms. Macci has kindly shared her article with us. If you look under documents on the right side of your screen, you will see an article, a PDF version of an article that might be interesting for all those who want to go deeper into the issue. But Ms. Macci, you have argued in favor of a notion of climate due diligence based on what would be called the holistic interpretation of human rights due diligence duties contained in UN guiding principles. So could you now briefly elaborate on perhaps national and also international regulatory developments in this regard on human rights due diligence and environmental due diligence, which I understand form a basis of your conclusions. Please, you have the floor.
Many thanks. Good morning, Mrs. Lichis, Professor Deva, fellow panelists and participants, and thanks to the German Chairmanship of the Committee of Ministers and to the Steering Committee for the kind invitation. In my comment, I will focus on the climate change responsibilities of businesses, arguing that the notion of climate due diligence is gradually consolidating. I will touch upon three aspects. First, the interpretation of the UN Guiding Principles on Business and Human Rights. Second, the emerging climate change litigation against corporations. And thirdly, relevant regulatory developments. Now, as underlined by Professor Deva, the UN Guiding Principles on Business and Human Rights do not expressly refer to climate change or to environmental harm. However, it can be argued that a coherent reading of the corporate responsibility to respect human rights requires interpreting its scope in the light of relevant environmental law and climate law standards. Under international human rights law, International environmental law standards have been used, including by the European Court of Human Rights and by the European Committee of Social Rights, to clarify the obligations of states. And today we are witnessing an emerging trend in climate change litigation which proposes an interpretation of the state's human rights obligations in the light of the Paris Agreement and of available climate science. A clear example of that being the landmark judgment Urgenda in the Netherlands. By analogy, the content of the corporate responsibility to respect human rights should be interpreted by the same principle of systemic integration, recognizing that in order to discharge their responsibility under the UNGPs, corporations must also identify and address the environmental and climate change impacts they cause, contribute to, or are directly linked to by their business relationships. In this perspective, climate change due diligence becomes a necessary component of human rights due diligence under the UN Guiding Principles on Business and Human Rights. This brings me to my second point, namely that some possible features of climate due diligence are gradually emerging from climate change litigation against corporations. Although most such cases are still pending, it can be observed that they generally revolve around two main themes. First, risk mitigation, namely the expectation that corporations, especially the big polluters, reduce their greenhouse gas emissions, and in some cases redress global warming-induced human rights impacts to which they have contributed due to their historical responsibility for large shares of greenhouse gas emissions. Secondly, the expectation that corporations integrate climate change considerations into their due diligence processes, finding ways to measure their direct and indirect impacts on climate change and honestly communicating to the public their climate impacts and the climate due diligence measures they have adopted. In some cases, for instance, in the pending lawsuit against Shell in the Netherlands, the plaintiffs explicitly resort to human rights arguments. Strategic litigation against corporations typically targets the so-called big emitters, those companies that have been proven to be responsible for a high share of global emissions since the Industrial Revolution, but it must be recalled that under the UN Guiding Principles, all companies, big and small, have a responsibility to exercise due diligence. This brings me to my third and final point. The human rights due diligence principle enshrined in the UN Guiding Principles has already taken the shape of a legal requirement in some jurisdictions. In France, the law on the duty of vigilance requires large corporations to adopt and implement a vigilance plan addressing both its human rights and environmental impacts. And based on this law, the oil company Total has been sued for allegedly failing to properly account for its climate change impacts in its own vigilance plan, for instance. At the European Union level, in addition to reporting obligations, such as those established under the Non-Financial Reporting Directive or the proposed Sustainability Reporting Directive, the Commission will table in the next few weeks a proposal for a directive that is expected to require all corporations based in or operating in the European market, regardless of size, to adopt and implement fully fledged human rights and environmental due diligence, including climate due diligence. Further regulatory developments might emerge at the domestic level as states come increasingly under pressure to realize their emissions reduction targets and to regulate corporate activities. The progressive clarification of the scope and attribution of the climate change-related responsibilities of states and corporations, including through the work of international organizations, human rights courts, and treaty bodies, will gradually help define a coherent system of different but interrelated obligations for public and private actors in which crucial governance gaps might be finally bridged, not least, as also recommended in the 2016 Committee of Ministers recommendation on human rights and business in relation to access to remedies for affected individuals and communities. Thank you very much.
Thank you, Ms. Machi. Mr. Lopez, I saw you joining for the moment, but now you've disappeared. If you could once again ask for the floor so I can add you to the panelists visible on the screen, so we can hear your comments from the perspective of International Commission of Jurists. It appears that perhaps some, yes, here we go. Mr. Lopez, you've disappeared again. Could you once again ask for the floor? If you want to open your mic, it's simply unmute mic, or I can do it for you. If you press release mic, it will remove you from the screen. I will open your mic now. Please, you have the floor.
Yes, please.
Please.
Yes. Can you hear me?
Yes, we can. Yes, we can.
I'm very sorry. I have problems with my camera.
That's fine. That's totally understandable. But we can hear you very well. And I would be grateful if you could elaborate on the work of the International Commission of Jurists. I understand you work on the clarification and development of international human rights standards applicable to both states and corporations, especially in the context of protection of environment. So if you could elaborate on these issues. Thank you.
Yes, ma'am. Thank you very much for your kind invitation. Thank you also to the Council of Europe. It's a pleasure and a privilege for me to have this opportunity to speak to you all today. You have asked me to speak about the ICJ's efforts to advance standards in the field of human rights, business, and environment. We have to start with the realization that providing an adequate answer to the challenges posed by climate change and environmental degradation requires a series of changes and developments, also at the normative as well as the policy levels. And the world of human rights and of business and human rights in particular are still poorly equipped to provide an adequate response to the challenges. And the ICJ, among others, promotes the progressive development of jurisprudence across the world with a view to clarify the duties of business in relation to environment and human rights. Cases concerning parent company civil liability for damages to human rights caused in their value chain have to do many times with environmental damage resulting from the releasing of toxic waste by mining companies that pollute water, land, and livelihoods, having a negative impact on rights to life, health, and livelihood. Court decisions in the United Kingdom and the Netherlands in recent years have clarified that the parent or principal company may have a duty of care responsibility towards people living in foreign countries and in the vicinity to where the company's subsidiaries operate. The parent company thus may be in breach of such duty of care when it deficiently intervenes in its subsidiaries' operations that cause the damage. This is an important jurisprudential development in relation to companies' global responsibility towards people and the environment that the ICJ and others are trying to entrench in international standards at the UN and elsewhere. We are also promoting clarification of standards by authoritative UN bodies, such as the various human rights committees. For instance, in General Comment 36 on the right to life, and the Human Rights Committee relatively recently held that the protection of life depends on state action to preserve the environment and protect it against damage, pollution, and climate change caused by activities of public and private actors. This adds to the already solid jurisprudence developed by the European Court of Human Rights and other regional courts on the duty of states to protect human rights. In General Comment 24 on the business sector and economic, social, and cultural rights, the Committee on Economic Social Rights held that the states should regulate businesses under the jurisdiction or control in its global operations. Similar statements are contained in General Comment 16 by the Committee on the Rights of the Child. All this contributes to the construction of standards of global responsibility for states and companies, a necessary element in the response to the global phenomenon of climate change. Last but not least, the ICJ also promotes clarification and development of standards in new instruments at appropriate UN bodies. For instance, the ICJ joined other NGOs to call on the Human Rights Council to recognize the right to a healthy environment as an autonomous right. Such recognition will have an impact on domestic legal orders and provide a strong guidance for state action for environmental protection, including against harm caused from business operations. The Human Rights Council has also created an intergovernmental process to elaborate a legally binding instrument on human rights and transnational corporations and other business. The current second revised draft that we are discussing contains several elements that address environmental protection and business human rights responsibilities. For instance, draft Article 6 provides for mandatory human rights due diligence that includes risks and impacts on the environment. Other articles refer to environmental restoration as a form of reparation for harms caused by enterprises. The draft treaty's Article 8 also provides for civil liability for parents or principal companies for harm, which would include harm also to a healthy environment. We hope this new treaty will be adopted in the near future. These are, Madam Chair, some of the few normative standard setting developments in which we are engaging, in which we are promoting this closer alignment between duties of states and business in relation to human rights and environment. Thank you very much for the opportunity.
Thank you. Thank you for this enlightening information. I think it's time now for questions and answers. I'll ask the keynote speaker and panelists to remain where you are. And now I can invite the participants to ask questions, either by writing a message or asking for the floor so that I can see those who requested to speak. While colleagues think about questions they might ask, I might put forward a first question. Professor Deva, I think it will fall to you to try to answer it. You've rightly emphasized the importance of cooperation both among states and among enterprises, considering the global nature of the issues we're dealing with. From the perspective of the Council of Europe, both in terms of human rights issues and others, it was always important to ensure that there's no negative fragmentation compared to the work of the UN as a global institution. What is, in your view, the approach from the perspective of the UN, the role of regional development in the considerations before the UN, and what is your view how at the level of international organizations we could ensure that there's neither duplication nor gaps remaining in our work? Thank you. And again, I invite other participants to put questions to our speakers. Thank you.
Thank you very much, Madam Moderator. This is an excellent question. Unfortunately, international law generally, not just in the field of environmental law or human rights law, is very much fragmented. Ideally, we would not like to see this fragmentation, but the sad reality, it is very much fragmented. I do not see the possibility of this becoming very cohesive in coming years or decades. So now the question is, how could we operate and make the best use despite these fragmentations? And my suggestion here would be that the Council of Europe should take leadership in pushing the agenda, not only within Europe, but all at the global level. Because if issues about climate change, if the Council of Europe is going to think only about Europe and they fix the house there, that will be a very important first step in my view. But that will not be a sufficient step. So we need to work bilaterally with different governments, especially in the global south, to bring them on board slowly, incrementally. And we also need to work with other regional associations in different parts of the world, whether this is African Commission, whether this is the Latin America systems, or in Asia, we do not have something comparable, but Asia, we can be divided into subparts of Asia, right? South Asia, ASEAN, the Pacific island countries, which are very much vulnerable to this. So I would suggest we need to work both at the UN level, which is, I would say, the top, and also at the bottom level at the same time. So we are trying to push towards harmonization as much as possible from both top to down and bottom up approaches. And then hopefully we will be able to make some changes. It will also be critical for the Council of Europe, in my view, to find allies, not only in the governments, but also in the private sector, in the civil societies, in academia, in lawyers, in national human rights institutions. So those partnerships, we should think beyond state to state, beyond company to company. And I think those partnerships, hopefully, will bring us together to understand that this is an urgent crisis. And if we do not act, then the future of the whole humanity is at stake. Thank you, Madam. I'll pass the floor back to you.
Thank you. Thank you. While I'm waiting to see whether there are questions from the audience, I also have another question for our two panelists at the moment. In his introductory, in his keynote speech, Professor Deva already mentioned the need to find a balance between voluntary commitments and normative requirements, between incentives and perhaps some punitive actions. And also Professor Deva just mentioned, again, the combination of this top-down and bottom-up approach. From your perspective, from the perspective of academia and also from the perspective of International Commission of Jurists, can we identify some principles to see which areas are perhaps more suitable for voluntary commitments based on various incentives, or where the area needs to be regulated through normative instruments? So if either of you care to elaborate perhaps on this as well, you go ahead.
Yes, thank you, Christina. I might focus indeed, first of all, on the need to clarify the standard. So on the one hand, there is really a need to clarify the standard for corporations. Arguably, also the state's climate change obligations need to be clarified, and hopefully international human rights bodies like the European Court of Human Rights will help us on that. But as concerns corporations specifically, there is really, research shows that there is still a lack of understanding, full understanding of human rights due diligence as a standard, let alone in its environmental and especially in its climate change dimension. So I think we need a binding standard that make it clear that corporations have a duty of care, that they have human rights due diligence and climate change due diligence obligations. But on the other hand, we need the voluntary guidance to help corporations, first of all, fully understand the standards in all their implications. For instance, what does it mean to be directly linked to an impact, and what are the possible consequences, but also guidance on how to, in practice, implement the standard throughout their policies and practices. The experience of, is still a young experience, but in the case of the French law on the duty of vigilance, we have seen many corporations actually ask for guidance, for clarifications about what the legal standard exactly implies and how they could translate it into business processes. So in this sense, voluntary guidance produced by authoritative international organizations and bodies might be a necessary complement to legal standards that, however, in my view, are needed and must be linked to an improved access to remedies for victims of a negative impact. Thanks.
Thank you. Mr. Lopez, would you like to respond to this question?
Yes, with pleasure, Madam. I will be pleased to answer, but respectfully will take a different line from my predecessors. I think we have to overcome very clearly these generalities of and mantras of a smart mix and other formulations that have been prevalent over the last decades and have given no strong results, no clear results in relation to human rights and environmental protection. I think what we need now is to move towards a different kind of norm in this area, a fair allocation of responsibilities. For this, businesses have to take the courage to assume and adopt more responsibilities, more obligations. And there is nothing better for that than clear messages from states through legislation and obligations, and especially strong monitoring and oversight. I think that's basically what facts on the ground are teaching us. In my view, pure smart mix has in fact meant basically a majority of voluntary initiatives and very little of enforcement and obligations. That has failed. That has failed, and we have to overcome that formulation. So we need to move towards a fair allocation of responsibilities now, more legislation, state action, monitoring, oversight. Thank you.
Thank you. Thank you for adding a different dimension to the discussion. I see there's a question in Kuro messaging from Ben Shi from the UN Human Rights Office of the High Commissioner for Human Rights. And the question goes as follows. Under the United Nations guiding principles, human rights due diligence is focused on risks to people. Do you see any potential issues in lumping in environmental risks as such into the concept of human rights due diligence? What changes may be needed to human rights due diligence processes to adequately address both risks to people and to planets? I think this is a very this is a question that might deserve its own conference. We look at individual rights and then a much broader issue. I ask if any of our panelists or Professor Deva would like to respond to this issue, how to find a coherence between risks to people and risks to planets. Please, either of the speaker, you have the floor.
Thank you very much for an excellent question. And the working group is currently drafting an information note to discuss some of these issues. What UN guiding principles entail for states and businesses in relation to climate change. So hopefully that note, which will be issued before COP26, will try to answer some of these questions. But in my view, when we say risk to people, we cannot narrow these risks to human rights only. And I think that is where I would agree with what Chiara was saying, that the due diligence can include climate change due diligence as well. So a holistic understanding of due diligence is perhaps a way to go about it, right? Because some people may also argue that labor rights are not human rights for the sake of argument. And there could be an argument then the human rights due diligence should not cover labor rights. But of course, we have overcome those issues. And I think at this point of time, this is a holistic understanding of due diligence that we're talking about. Having said this, a point of departure for me from Chiara would be that the human rights due diligence and climate change due diligence, and I'm also working on a paper on this, they're not identical. And I think we cannot cut and paste what UN guiding principles provide and what is needed to deal with due diligence in the context of climate change. We need to extend and go beyond the UNGPs, in my view. We would need to add some additional yardsticks. Let me give you one practical example. When we talk about adverse impact on human rights, a company can very easily identify who are the affected, potentially or actually affected people by the subsidiary, by the supply chain. How will it identify in the context of the climate change? Who is not impacted by a very big multinational doing oil exploration, and that causing to climate change, who is not affected by that directly or indirectly? So how is it going to consult 7 billion people? So I think there are definitely challenges. So the idea of human rights due diligence is a process. And I think that is my second point. And I hinted about this, that we should not see this as a panacea because it is merely a process. We also need to develop tools which are outcome oriented. And that is where I was saying that we need to make fundamental changes and shifts. We celebrated plastic bags in the past, and now we are trying to get rid of the plastic bags. Similarly, we are now moving towards battery-operated vehicles. But will it be the case that after 20 years and 30 years from now, we will find these battery-operated vehicles part of the problem? Because now they're part of the solution. But will they become part of the problem in future? I think these are the hard questions we should be asking now at this particular point of time, because there is a push for deep sea mining in the Pacific. Because for batteries, we need minerals. And where do you get minerals? Either you displace indigenous peoples or you start mining in the ocean. And what impact this is going to have on the climate? So I think these are larger, big questions. And as Madam rightly pointed out, perhaps we need another conference on that. But I will stop for now. Thank you very much for this opportunity.
Thank you. I hope you can still hear me, because for some reason my camera has... okay, I'm back on. Chiara, Carlos, would you want to comment on the question of scope of human rights due diligence? Let's put it this way.
This Chiara, you go first.
Thanks, Carlos. Yes, no, definitely, I agree with the challenges highlighted by Professor Deva. I will add that another challenge will be to clarify how processes of human rights due diligence and of climate due diligence can be carried out consistently and coherently, meaning that one cannot function fully without the other. For instance, project relating to carbon investments. There are corporations that adopt internal carbon footprint and greenhouse gas policies, but then fail to pay equal attention to human rights-based management policies. The vulnerability of a particular community in designing a process of human rights due diligence cannot be effective if it does not take into consideration the special climate-related vulnerabilities of that specific community. And this is especially true, of course, for communities that suffer more than others the exposure to the adverse impacts of climate change, so water scarcity, drought, extreme weather events, and so on. At the same time, a company putting in place a project related to clean energy and alternative sources of energy must take into consideration the potential impacts of that project on the human rights of surrounding communities. So how do we carry out these processes that, as Professor Surya said, must be clarified and won't be identical? How do we carry them out in a way that is coherent and in which they reinforce each other as opposed to contradicting each other in their means and results? So this is one of the crucial issues to clarify. Thanks.
Thank you, Chiara. Carlos, your comments, perhaps? I hope, Carlos, you can still hear us. Would you like to comment on scope of human rights due diligence.
Can you hear me now? Yes. I was saying that I largely agree with what has been said. I would add simply that we are now in a moment in which there are a few initiatives that we are looking with some expectation, especially the French law on environmental and human rights due diligence. So we shouldn't forget the formulation of the French law about the plan of vigilance speaks about human rights and environment. So I think the interpretations and the implementation of that law will probably set the path towards, in the future. Now, that being said, one of the things that for me is very clear is that most of the risks linked to the environment and protection of the environment are also intrinsically linked to the realization of human rights, fundamental human rights such as the right to life, health, well-being. And to that extent, human rights due diligence by necessity will comprise also environmental due diligence. So I think we need to combine those perspectives as well. And just to finish, one issue we need to put on the table for further research and reflection is whether beyond human rights, nature and the planet also have, the earth have also rights, as some jurisdictions have already advanced in some parts of the world. Thank you.
Thank you very much. We have almost exhausted the time that's allocated to us, but before concluding the session, I will ask all three panelists to share some final observations, but very briefly. It's perhaps a minute each, and if at all possible, in that minute, address the last question that we have on Kudo platform, which basically asks about role of further binding rules, for example, due diligence legislation, whether these binding rules are in addition to the smart mix of voluntary incentives or legal obligations, or do they exclude the smart policy mix? So if our three panelists could recap and perhaps address this question. Please go ahead. Professor Deva, perhaps you will start.
Thank you very much. So I will say that the smart mix is a very widely used but poorly understood term. Everyone talks about smart mix, but perhaps they mean different things. For me, smart mix is an integrated theory of regulation, which basically means that no one tool is enough to regulate difficult regulatory targets like companies. And that's why we need to use all available tools simultaneously at the same time. That could include giving them incentives in terms of tax rebates, public procurement, easier access to loans and finance, for instance. That would also require market forces, consumers and investors to put pressure on businesses. And that would also require strong civil, administrative and criminal liabilities for businesses who are not willing to eat the carrots. So we need carrots and sticks, not in sequence, but at the same time on the table. And then let businesses decide whether they prefer carrots or they prefer sticks. I will conclude with that. Thank you very much.
Thank you. That was a very vivid description. That's punitive for those who don't eat the carrots. I think that will remain for me as an interesting comparison. Chiara, your concluding observations, please.
Thanks. Yeah, on the smart mix, I agree with Professor Deva, but I want to bring up another concept of the UN Guiding Principles on Business and Human Rights, which is the notion of polycentric governance. I think that all levels of society need to play their part in the energy transition and in addressing the impacts of climate change. And here is where international organizations can be a powerful forum to nudge states, so to speak, to make their part. And this is extremely important because of the political sensitivity of the matter. I mean, the concept of climate due diligence that we have discussed has huge implications. For some companies might imply an essential, a fundamental shift in their core business, a shift that, of course, is increasingly encouraged by market incentives because the market is changing, of course, but a shift that is still extremely costly and politically controversial, so to say. States must not be afraid to treat this difficult matter because it is urgent to act, and at the same time, corporations must be supported in understanding the relevant legal standards and implement them into their operations. So I really praise the work of the Council of Europe and of the steering committee, and I'm looking forward to reading the results of their work. Thank you very much.
Thank you. Thank you, Chiara. Carlos, your concluding remarks, please.
I think the question of sorry, can you hear me now? Thank you. I was saying that the question of carbon at stake is fundamentally different from the question of legislation or no, hard laws of law. I mean, hard law doesn't necessarily mean sticks. Could be also incentives, could be also setting very clearly the expectations, the objectives, the path, the processes to follow. And no, I think the carrots and sticks balance also has to be ingrained and enshrined in legislation. Clearly, now no process, no initiative that is currently underway is actually threatening to completely eliminate the space for autonomous voluntary initiatives or self-regulation. Self-regulation and autonomous initiatives are always necessary. There is no country in the world that can regulate in detail or every single detail of business operations. No, that's not possible. But that's not the issue. That's the wrong question. The key question is that so far in the last decades, we have had a prevalence of just voluntary initiatives, where there are thousands of them at many levels, at the business level, industries, states, and global business associations, United Nations agencies, NGOs, international NGOs, academic institutions, etc. We have very little of legislation and especially international treaties. So I hope the Council of Europe will break with that vicious circle and give us something that we all look forward to. Thank you.
Thank you. Thank you to the three panelists. I'm very, very grateful for your presence and for your contributions. I don't think I should and I could summarize the discussions, but perhaps 2 points could be made at this stage. First, I think we all recognize that we're dealing with what could be called a moving target, which requires us to constantly adapt and adjust to the tools we use, to the to which instrument we emphasize, whether it's incentives or whether it's the stick side. So it's, again, we need to remind ourselves that there's no one single solution for one single point in time. Another conclusion, which is similar to what I always try to remind my counterparts at the domestic level: protection of human rights, obviously same as protection of as the protection of environment. It's not an event; it's a process. It's something that will probably never be complete, which brings us back to the question of moving target and being constantly aware of the need to adjust our instruments and the tools we use. Once again, thank you very much for the interesting discussion. It's I'm very sorry that Judge Chanturia was prevented from joining the conference. We're slightly behind time, but according to the program, now we have a 10 minutes break until 10:30. Thank you once again to all the panelists, and I wish the participants of the workshop and speakers in the next panel interesting discussions and a lot of food for thought. Thank you very much, and it's time for break. Thank you.
Thank you. Bye.
Good morning and welcome back from our virtual coffee break. My name is Nicola Wenzel. I am government agent for Germany and member of the steering committee on human rights. But more interesting for the purpose of this conference is I'm leading the business and human rights team at the Federal Ministry of Justice in Germany. It is a great pleasure for me to moderate our second panel on access to remedies for human rights violations related to business and the environment. Access to remedies is an issue that is central to all discussions on business and human rights, be it at the national or the international level. It is not enough for victims of human rights violations to have rights. They also need means to enforce them. That is the reason why the United Nations guiding principle access to remedy as the third pillar of the principles. Ensuring access to effective remedies for corporate human rights violations related to the environment is a challenge. There are ongoing discussions at the national, at the European, and at the international level on whether additional measures are needed to ensure that victims have better access to courts. At the same time, non-judicial grievance mechanisms are being developed and used. The difficulty of providing access to remedies in the triangle of the state, the business, and the victim is enhanced in environmental matters by the fact that the normative background is in flux, as we have heard in the first panel. The content and reach of states' human rights obligations related to a healthy and sustainable environment is being negotiated right now in courts, in parliaments, and in intergovernmental circles. It is against that background that we will focus on remedies in environmental cases today. I am very grateful that we have been able to put together a panel of highly distinguished speakers with a high level of expertise and practical experience in the field. Our keynote speaker, which we can already see on the screen, is Professor Ulla Gläser. Ulla Gläser is Professor of Mediation, Conflict Management, and Procedural Theory at the European University Viadrina in Frankfurt-Oder. She currently works on a research project on the design of grievance mechanism in the field of business and human rights commissioned by the German Federal Ministry of Justice. Ms. Gläser will explore the potential of non-judicial remedies. To begin our discussion not with judicial remedies, but with alternative means of dispute resolution may seem counterintuitive, but I'm sure, Ulla, you will be able to explain to us why it is not.
Dear Nicola, thank you very much for the introduction. Let me share my screen. Oh, just hang on. I'm sorry, I think I need to use this type of screen sharing, otherwise I cannot see the rest of this presentation. So hello everybody, and thank you for the introduction, Nicola. I today want to talk to you about the potential of non-judicial remedies. And I would first like to ask the question, why should we talk about non-judicial remedies at all? What does ADR, out of court dispute resolution, mean in the context of business, human rights, and the environment? What does ADR have to offer in this context? And what are the design components of ADR-based grievance mechanisms if you understand them as conflict management systems? Last but not least, what could the Council of Europe contribute? So why should we discuss ADR at all? The struggle for effective legal protection of human and environmental rights is still in full swing, both on the doctrinal and the procedural level. A great number of NGOs and individuals have put a lot of effort, time, and legal creativity into fighting for the possibility to bring effective claims at the intersection of human rights and environmental concerns before national courts and the European Court of Human Rights. To suggest to change the forum and change the focus away from judicial remedies and turn towards alternative means might thus evoke skepticism or even resistance. This is understandable, and that's why I want to place an important message of my presentation right at the beginning. ADR approaches must not impede access to the courts or take away resources from judicial protection. So ADR should not bite the apple of the court system. Instead, ADR should be understood as a complementary offer of mechanisms. So when we discuss the potential of ADR today, we are not suggesting to change the playing field, but to expand it, and thus expand the procedural options for movement for affected individuals and communities. And we all know that this is needed. So the image would rather be this back there. Why is it needed? Many individuals don't know where to turn to find access to justice or access to effective remedy. They don't see a procedural pathway, or they don't see a well-founded claim. And they are afraid maybe to put a lot of work into preparing a claim and still not being heard. There are lots of factual, practical hurdles, from lack of financial resources, language barriers, literacy barriers, you name it, and we have heard some of it in the panel first, that impede individuals to enter procedural pathways. And even if they can enter, they don't often know what to find and what to expect in terms of procedure and outcome. And that's why it is worthwhile to look at ADR and the alternative procedures it has to offer. In addition to litigation, we, and you all know that, have a great variety of procedures reaching from mediation over conciliation to arbitration. And basically mediation and conciliation really have the potential to contrast litigation in ways that need some creative enhancement in the context of human rights and environmental protection. But it's a counterpoint. It's a more autonomous, a more flexible procedure, and it can be faster and can provide for a lot of variations in procedural design. And I will talk about that in a minute. So if we talk about ADR, we mean alternative approaches, but these procedures need to be embedded in conflict management systems. So we're talking not only about a procedure in and of itself, but we're talking about grievance mechanisms that need institutionalization, that need implementation strategies, and on all levels, from the specific procedure to the implementation, they have to take into account the legal system that surrounds them and that creates certain pathways in and out of ADR on the one side, and the structural power imbalance that is typical for human rights and environmental protection cases, or can be typical for many of these cases. So the design of the grievance mechanism needs to react to these circumstances. Institutionalization means where to place a grievance mechanism, which organization or institution can carry the mechanism, and how is it financed. And there we have to look both at aspects of effectivity and outreach, as well as neutrality and integrity. Implementation means how to bring the process, the grievance mechanism, to the affected people, how to communicate the possibilities and options that are there, how to interact with stakeholder groups and weave the mechanism into local circumstances on the ground. Last but not least, as I've already said at the outset, ADR is meant as an appropriate dispute resolution. Appropriate means it's not necessarily better, it's not necessarily always the right way to go. We have to look closely at the different layers of options and be creative to find ways to put the advantages of the legal system and legal protection in a good match and combination with the procedural chances and benefits of ADR. So it's not an either or, it's a both and that we need to discuss. And ADR works the better, not in the shadow of the law, but in the light of the law. So we need to foster legal protection in order to work, for ADR to work better. So ADR approaches are not meant to impede access to the courts. They should be understood as complementary mechanisms that can compensate for factual hurdles and weaknesses in the system of judicial remedies. And even if the judicial remedies would work optimal already, ADR still has to offer specific benefits, namely more flexibility. And looking at both apples that I just showed you, we just want to provide for more options and thus more protection. What does ADR have to offer specifically? First of all, ADR offers interest-based decision-making. That means we don't have to stick closely to the law, because we all know the difficult discussions. Is there a basis for a claim at all? Which standards of protection should apply? Have these standards been violated? How do we take into account specific vulnerability of individuals and groups? Who has been responsible, etc., etc. In ADR, the discussion about material standards can move away from the discussion of legal claims, at least to a certain extent, and thus we can include other important criteria, the interests, needs, future perspectives, and abstract criteria. So we can discuss without pressure of precedent, both looking at a precedent or having the pressure to create a new precedent. We can look in the individual case how to take into account specific vulnerability, cultural norms and values, the interests of future generations. We can even move away from the current anthropocentric standards, because we talk about environmental harm as impact on humans. We can look at the own rights, could discuss at least the own rights of animals and non-human environment, and we could take into account long-term political, ecological, and economic goals. So the plate that we discuss is much broader than the topics of a usual lawsuit. Who can bring these interests to the table? Here, ADR offers more flexibility regarding participation and procedural design. So in addition to the parties in the strict sense of procedural law, we could also invite indirectly affected individuals to the table. They could bring support persons and experts. Representatives of stakeholders, interest groups, and communities can be invited. Representatives even of future generations and the non-human environment, and so on. This does not necessarily mean that all of these actors have the same status and right to be part of the decision-making, but they could have a consultative role, and all this can be negotiated before the process starts on the material discussion. So ADR could offer more access, more voice and voices, and more expertise, maybe even. The next issue that is fast response options. We all know that legal redress takes time. Many lawsuits take 2 to 3 years at least, and during this time, damages are aggravated usually. There's the danger of broadening of damages, and ADR can offer speedy access to remedy. It's low threshold, and you can negotiate interim measures at the very start of an ADR procedure in order to stop certain dangers until you find a negotiated solution. ADR also can offer custom-fit solutions and implementation strategies as an outcome of the procedure. So the flexible, customized remedies can include monetary and non-monetary remedies that can look at compensation for done harm and prevention of future harm. Usually, negotiated solutions bring with them a higher commitment of the decision makers, and one can include tailor-made safeguarding of obligations that have been negotiated. So ADR can offer a sharp sword, but it needs to be negotiated. Last but not least, it's easier to include preventative approaches in ADR procedures. You can negotiate future arrangements directly, whereas the law usually looks back to the past, what has happened and how do we pay out damages for that. Here we can directly look at the future, use grievance mechanisms as such as early warning systems for the detection of structural problems, and we can effectively improve them. Of course, this needs the goodwill of all participants, and that's one of the basic dilemmas sometimes. I don't want to not talk about that. After all, grievance mechanisms can feed into risk analysis and thus give companies and states an even more detailed image what's going on the ground and how people, groups, communities, individuals experience the effects of production circumstances on the ground. Which types of non-judicial grievance mechanisms are there? There are state-based mechanisms, the national contact points, for example, and there are non-state-based mechanisms, either at the individual company level or based at overarching organizations as multi-enterprise associations, trade associations, or multi-stakeholder initiatives. On any level, there should be the design of grievance mechanisms should fulfill some design standards and should look at continuous quality development. And I will just briefly sketch different design components of grievance mechanisms. The UNGP, the United Nations Guiding Principles on Business and Human Rights, have put out 8 effectiveness criteria that you can see here that grievance mechanisms on all of the mentioned levels should adhere to. These criteria are still quite abstract, and if you go on the operational design level, we have different components to design. First of all, let's start with the communication. If you want to install a grievance mechanism, you need a lot of outreach and networking with stakeholder groups. They should be able to give input or even co-design mechanisms and make them thus more accessible and usable for the people on the ground. There need to be formal and informal conflict management contact points. Where do people go to? Low threshold accessible entry points into a process. There need to be systematic criteria for choice of procedure, because mediation or conciliation or arbitration is not always the right thing. We move in this triangle of interest-based, rights-based, and dialogue-based options that ADR has to offer. And these options can be combined in a customized way to fit the specific case. And cases with environmental impact problems are often complex cases with a lot of stakeholders and a lot of people that need to be taken into consideration. And they need not only facilitated dialogue, but also sometimes investigative elements and hardcore rights-based discussion. But ADR offers the options to marry the benefits of different categorical procedures into a customized procedure for an individual case. The procedure, whichever has been chosen, needs procedural standards that are transparent, is most important, and predictable for the parties who enter the process. And in our research project that Nicola has mentioned, we have looked at many different grievance mechanisms and come to many different categories of process design. And so in the project, we have worked out a long checklist or construction kit for procedural standards, as you can just sketchily see here as an example. The conflict handlers, be they mediators, conciliators, or arbitrators, need to have the legitimacy in the eye of the people who use the process. They need qualification, and they need a neutral stand to be accepted. And we could talk a lot about that, but we will move on to quality development. This means every process needs to be a learning system. There's a lot of there are experiments being started, and of course there needs to be improvement and learning from the practice. And so on level 1, there need to be very good feedback mechanisms to optimize the grievance mechanism itself by a circle of learning, systematic feedback, and noticeable reactions to this feedback. On level 2, the grievance mechanism in and of itself can feed back into the risk analysis and thus ultimately, hopefully, contribute to the improvement of local working, production, and living conditions. So, at the end of my talk, what can the Council of Europe contribute? It can establish, it could establish its own grievance mechanism as a prototype and an experimental kitchen, so to speak, for these types of ADR offers. It could initiate legislation regarding minimum standards and quality assurance criteria for grievance mechanisms. Maybe, but what it definitely could do is to act as a clearinghouse via a dynamic web portal and workshops as the one today, to provide for a blueprint, a construction plan for high quality grievance mechanisms, to give an idea how this could look like, to provide a forum for discussion for design questions and good practice examples, the documentation of exemplary cases, and cross-border exchange and network building of experts. So I'm looking forward to discuss all this with you, and I'm curious about your opinions. Thank you very much.
Thank you, Ulla, for this very interesting introduction into the world of non-judicial remedies that has in fact already sparked objections in the chat. We'll have a look at that later, but right now I would ask our panelists to request the floor. And I'm just giving them the floor so then we can start our panel discussion. Now I can see most of you and would like to welcome you. Before introducing our first panelist, I would like to remind everybody that you have the possibility to ask questions via the chat or by requesting the floor later on. Our first panelist is Richard Miran. Mr. Miran, you work at one of the top law firms in the UK and have represented thousands of victims of business-related human rights and environmental violations before UK courts. As a litigator, what is your take on access to remedies for environmental damages caused by business activities.
Thank you, Madam Chair. I hope you can hear me.
Yes, we can.
Thank you. Good morning, everyone, and thank you to the Council of Europe for inviting me to this workshop. Consider the following ongoing and recent events and circumstances. The widespread pollution of the Niger Delta and the long struggle of communities to obtain justice against Shell. Compare that with how swiftly BP was forced to cough up over the Deepwater Horizon spill in the Gulf of Mexico. Trafigura dumping toxic waste in Côte d'Ivoire. The scandalous practice of ships at the end of their operational lives being beached on the shores of Bangladesh and broken up by low-paid workers unprotected from the toxic materials within the ships. The lead poisoning of generations of children around the Kabwe mine in Zambia. These are all examples of cases in which my firm has been involved. And off the top of my head, I could reel off many further examples of environmental wrongdoing that would not have been tolerated or gone unpunished, at least not to nearly the same extent in the global north. There are various reasons for this state of affairs, including poor enforcement of laws and inadequate criminal sanctions. But access to justice is a significant factor. Being able to effectively hold a corporation to account legally for environmental damage may not only provide much needed redress for victims, but also serves an important preventative function. A judicial process can identify impartially the precise causes and responsibilities for damage. The financial and reputational consequences may provide a salutary warning to the business in question and others to act responsibly. Specific barriers to judicial remedy have been widely discussed and are indeed alluded to in Pillar 3 to the UN guiding principles, and they include in particular intimidation of victims. For example, environmental protesters who were abused and tortured by the Peruvian police with the alleged assistance and participation of Monterrico Metals were themselves subject to criminal prosecution, whereas their abusers were not. The European courts have jurisdiction over home-domiciled multinational parent companies, but this then raises the corporate veil obstacle. English law, in particular, has developed to cater for parent company responsibility in certain circumstances, which will be of value in states with English law-based systems, but not elsewhere. Access to documents, who knew what, when, what decisions were made, and by whom. The disclosure process is more limited in the European Union compared with the UK and other common law states, which can mean victims' lawyers fighting with one hand behind their backs. Class action mechanisms. Typically, in environmental cases, large numbers of people are adversely affected. It's not feasible to pursue their claims individually. The tens of thousands of South African silicosis victims would never have been able to pursue a claim against 32 gold mining companies without a class action mechanism. Access to legal representation and technical experts. This is crucial for victims where complex technical issues are involved, for example, concerning the cause, extent and consequences of environmental damage and the evaluation of the nature and cost of remedial action, and where businesses invariably have an army of lawyers and experts advising them. Consequently, there is an inequality of arms. Non-judicial remedies could potentially assist in the ways outlined by Professor Glesser, to which I would add that arbitration is an example of a non-judicial mechanism that could certainly be of value. In that regard, I refer to the Hague Rules on Business and Human Rights Arbitration, launched in December 2019. But operational grievance mechanisms are often hastily convened by corporations in response to letters of claim from lawyers. Unless the safeguards outlined by Professor Glesser are implemented and victims have effective legal representation in the process, the concern about such grievance mechanisms is as follows: that victims will be wary of company-operated schemes, that victims could be bought off for paltry sums, that human rights abuses will not be properly investigated and will be brushed under the carpet, that the result will be no justice, no accountability, no deterrence or prevention of human rights abuses and or environmental damage, and business as usual. The fear is that for some businesses, these downsides may be the attraction of non-judicial mechanisms. Thank you very much.
Thank you, Mr. Miran. You made an important point by saying that there is the danger that non-grievance mechanisms may be hastily convened and set up, and that we need safeguards in order to ensure that basic procedural guarantees are respected in that context. And that takes up a comment that has also been put onto the chat, and I think we will have to deal with that question in detail later on. But I would now first like to turn to our next panelist, Maddalena Neglia. She works for the International Federation for Human Rights, an international NGO very active in the fields of human rights. Mrs. Neglia, could you explain to us what role your organization plays in helping victims of environmental damage exceed remedies?
Yes, hi, good morning everyone. Do you hear me well?
Yes, we hear you very well.
Perfect, thanks. So thank you very much for the invitation to the German presidency and also to the Council of Europe. So FIDH, International Federation for Human Rights, which I represent here today, is a federation that collects more than 190 human rights organizations that are working in more than 100 countries around the world. And since many years, almost 20 years, we work on the issue of business and human rights particularly, and we have supported and worked together with our members and partners to help them fighting against human rights and environmental abuses linked to corporate behavior. And we have done so using different strategies, fora, and type of actions. So I just want to mention two of them now. A type of support that is traditional, what we offer is a legal and material support. For example, we have recently filed together with our Ecuadorian member, Acción Ecológica, and other two local organizations, so the Union of People Affected by Chevron Texaco and the Waorani community, a claim against an oil company in Ecuador for their responsibility in using gas flaring and the contribution that this activity does to climate change, and thus the link of this to indigenous community of the Waorani community that is located in that specific area of the Amazon where the operations of the company are taking place. So this is an example of a type of cases that we support, and we try to help our members bringing to the court. Another type of support is knowledge sharing. So, for example, since 2011, we have published and we regularly update a manual that is called Guide Corporate Accountability for Human Rights Abuses, a guide for victims, NGOs, on recourse mechanisms. It is a manual that aims to provide NGOs, but also affected communities and individuals, but also practitioners with support on different type of mechanisms, the judicial and non-judicial, that are available to try to get redress for human rights abuses linked to corporate behavior. And I take the occasion here to announce that this year we're going to publish the latest update of this material in June, in the month of June of this year. It will be also interactive, and we will take advantage of this moment to take stock also of all the important developments that are happening in the field of climate change litigation against corporations, for example, which we have heard this morning, but also in the field of the duty of care doctrine developments that are taking place in the UK, as Mr. Miran just remembered. But what we can say is that there is a need, in our perspective, for NGOs to step up their support, particularly in the use of local mechanisms or of national and testing national judicial systems. It's what we are trying to do, for example, with the Ecuadorian case, because sometimes what we see is that in the case of Ecuador, there are existing mechanisms that are very interesting. For example, there we have tried this constitutional mechanism that the Ecuadorian system has for the immediate protection of constitutionally recognized rights. And the fact that in Ecuador, the constitution recognizes directly the rights of nature and very strongly the rights of indigenous people, it's something that it's very interesting. So we would encourage as well the use and the test of national mechanisms, even though they have a lot of limitations, particularly on the enforcement part. But it's interesting to learn as well, I think, from the European perspective, also from other systems, legal systems. And also another aspect we would like to foster is the collaboration between human rights and environmental organizations internationally, but particularly also at local level, because the two types of violations are closely interconnected. But and the collaboration can only strengthen the effectiveness of the actions. And concerning, lastly, the non-judicial remedies that were discussed at the beginning, we have, of course, also in the course of our experience, tried many of them, from the national contact points that are included in the OECD guidelines to also sometimes companies-led operational grievance mechanisms. And I have to say that our global assessment from the experience is rather negative of these mechanisms, because, of course, yes, they offer at first instance flexibility, more flexibility, and easier access for NGOs and affected individuals and communities, but there are huge questions about their legitimacy, independence, sometimes impartiality, and also often they are not able to live up to the promise to deliver an effective remedy and justice. And the reasons are different. There are many mechanisms we could talk about, but one of the points in common, which I want to underline, is the absence of the clear recognition of the responsibility of the perpetrator, in this case, the company, which is a fundamental component of justice. And for the communities we work with, there is only one part of the remedy, which is, for example, compensation or the material remedy of the situation. But the other part is the recognition of the responsibility, and this rarely happens with the mechanism that we have tried and we have used. So in the end, while non-judicial remedies with appropriate safeguards could have a role to play, particularly probably for minor violations, our experience tells us that they cannot exist if not in support and together with strong and effective judicial systems that are the only one able to deliver justice and make companies really accountable for human rights and environmental abuses. Thank you.
Thank you, Ms. Neglia, for this forceful statement highlighting the role, especially of local NGOs, to help victims of corporate human rights violations access remedies, and also for confirming a point that was made in the intervention by Ulla Gläser at the beginning, that it is essential not to limit remedies to non-judicial remedies, but that we do need strong and independent courts that can be accessed by victims to decide on claims made by these victims. Our next panelist is Diego Quiros. We can't see him on the screen right now, but I hope we will once he takes the floor and speaks. Mr. Quiros is affiliated with the Scottish Human Rights Commission, which is accredited as a national human rights institution by the United Nations. Mr. Quiros, could you elaborate on the role of national human rights institutions in enhancing access to remedies for victims of corporate human rights violations? There might be a technical issue here. I can't see Mr. Quiros on the screen, and I can't hear him either. So in the meantime, I would propose that we turn directly to Margaret Freeling and hope that we can get Mr. Quiros on screen in the meantime. So, Ms. Freeling, you are the Associate Director of the Fair Wear Foundation, a non-profit organization that works to support and improve conditions for workers in garment factories. Fair Wear has developed an independent complaints system for workers. What can we learn from your experience and the complaint mechanism that you have developed for the design of non-judicial remedies in environmental cases, Mrs. Freeling.
Thanks a lot, Ms. Hensel, for participating in this hugely interesting conversation about human rights and environment and about the access to remedies. And thanks for the Council of Europe and the German presidency for organizing this. Indeed, the Ferrer Foundation is a multi-stakeholder governed organization. I think that is an independent aspect in relation to the topic that we are discussing about, that works on improving working conditions in the garment sector together with brands that are our member. And in relation to the responsibilities for providing access to remedy for those brands, I'd like to stress that a grievance mechanism is only one part of it. We have been talking earlier this morning about the human rights due diligence responsibility, and I'd like to add to that the responsibility to engage with stakeholders and also to facilitate, in our case, factory level grievance mechanisms. So our grievance mechanism is really to be seen as a safety net. So connecting to the words that Ulla Glaser addressed about the apple, we're certainly not there to bite the judicial apple. It's really meant as a safety net in addition to it. And I won't speak a lot about the additional benefits of a system as such, as Ms. Glaser already has done that. Our grievance mechanism is really embedded in our approach, as I say, because it's part and parcel of other responsibilities and duties that I see for brands in relation to human rights. And it's really based on the supply chain responsibility so that we can link, and that's also one of the benefits, I believe, in this case of a non-judicial mechanism. We can link the victim to the other end of the supply chain and tap into the influence that that brand has, and also link it to the purchasing practices that that brand has. I believe we have an added value to organize this as organization for our members, to make it a joint system, and also to have a role in accountability, because I believe transparency is really key to also address some of the concerns that have also been raised towards non-judicial mechanisms. And those concerns are there. Maybe to explain a bit about the elements of our channel. So in practice, it means that we have a channel, a helpline with a local team in the different countries where our members are sourcing. So workers, unions, stakeholders, factory managers can approach us with issues whenever they see their rights are violated, through a phone line, through an email, through our website. So there are different ways to reach out to us. And next to having this channel in place, the important aspect is then also to have the capacity, local capacity in place to ensure the accessibility. So we work only with local complaints handlers who speak the local language, who are familiar with the context of the workers. And they also are sharing together with our brands the materials to make sure that the rights holders are informed and aware about not only about their rights, but also about our mechanism. Another element of the system is, of course, our information management system, which makes it possible to link an issue to the brand, and the public reporting for all the complaints that come in and that we are handling. We report publicly on our website for each and every case, also linking it with the name of the brand as a way of accountability towards stakeholders, but also for others to learn, and also for linking it and having it feed into the risk assessment and the due diligence activities of the brands. As I said in the beginning, I really believe that it is only one single part of a more integral system. So I see our role as Ferrer Foundation really as facilitator to provide the system and to do that for more brands, to avoid that each and every brand sets up a single system and that we go towards a myriad of different systems that workers don't anymore whom to call anymore. So we're keen on having this as a joint system, and also to cooperate, by the way, with other multi-stakeholder initiatives in our industry. I see our role also to have this clear network in engaging with stakeholders, because we need to be able to investigate the cases. So the way it works is that when a worker or a union or a factory manager calls us or reports a case to us, we will link it to our member brand, who has then the responsibility to hear the other side of the story of the party who's being accused. And then we try to engage the parties in dialogue. And if needed, if there is a difference of opinion between the two, we do, with our local team, an independent investigation. And I believe we can have that independency because of our multi-stakeholder setup. We have both unions and employers' organizations and NGOs in our governance structures. And this independent investigation is usually a good step to move towards a remediation plan. In a lot of cases, I must say, there is a gray area. It is not black and white. For example, a simple example, people that are doing excessive overtime, usually that is not to be proved by the books of the factory manager, because of course they try to hide it. So then engaging in a dialogue when there is not a clear black and white case can help to together come to a solution. And for this, the success of the system, I believe, is really linking the victim to the influence of the brand. That is clearly the case when there is a link to the purchasing practices in the vision of the United Nations Guiding Principles. When a company contributes to, there's a clear responsibility to also engage in remediation. But also when it's linked to it, what I see in a lot of cases, that there might not be a clear link between the company, but the influence that they have within the supply chain and the responsibility that they feel for human rights compliance is helpful for solving issues further down in the supply chain. So I'd like to stress that our role is merely as a facilitator, as an independent organizer to engage and maintain the communication throughout the whole process with the complainant since the beginning, but also after the complaint to verify whether the complainant is satisfied with the solution. And we will also report that. And that the responsibility to deal with the issue stays and remains, of course, with our member brand. So there's a clear distinction in responsibilities. To give an idea, we have now currently, I think, close to 130 brands that are connected to Fair Wear Foundation. And we deal with more or less 150 complaint cases in a year. Most of them, or a lot of them, are related to wages. A lot of them are related to employment relationships, but also several of them are, for example, related to freedom of association or health issues. And health issues there might be sometimes a relation with the environment. But I'll come to that. I think important to say here for the mechanism to work is this accessibility. People need to know and be familiar with the context of the rights holders of the workers and to speak the similar language. And there shouldn't be any hurdles financial-wise, for example, to approaches. So our local team is also very supportive of that. There needs to be awareness and trust. So there's a reason that it's embedded in our system. Our local team members usually not only visit the factory locations or the stakeholders to explain about the mechanism, but are also there to train about the rights and obligations within Fair Wear Foundation. They're there to train about communication, for example, or they visit the factory locations for other reasons, so they are familiar with our organization as such. And I believe in this transparency as a key role to be able to be held accountable, both us as organization and also our members. There are, of course, challenges for a non-judicial mechanism as such, and we've been touching upon those as well. Ms. Madalena also mentioned them. We can look for solutions to solve a problem with the help of both parties. But we don't have the legal mandate, of course, to put sanctions other than we have a bit of leverage on our members, of course. We can put them out of our membership club. But there are no sanctions for example, the factory managers. For that, there is really the judicial mechanism to go towards. For example, last week we had a very unfortunate case, I must say, of a worker telling about the situation of being raped by a supervisor within the factory location. That is clearly a criminal act. There we support the victim together with the network we have with our stakeholders to make this to see this as a criminal case. So there's a limitation. We are, I think, very successful in looking for solutions for the problems. I've been thinking about enhancing, because that has been also a question, this to environmental issues, because our mandate, of course, is at the moment limited to our scope that is focusing on labor rights as part of human rights, and to the manufacturing process. So if we align our work with United Nations Guiding Principles and the OECD guidelines, we are discussing currently also how does this work for other tiers in the supply chain, and how does this work indeed for environmental issues. I think what is very important is to ask the question, is the framework clear? Because we have an admissibility step, of course, in our process. So for environmental cases, there needs to be a clear framework. And I see here a clear role also for the Council of Europe to make clear what that framework in relation to environmental aspects of human rights is and should look like. The other challenge I would see there is to raise awareness and create trust among the rights holders, because adding environmental issues to such a system, I'm not sure whether our brands and our local teams can reach all the potential affected people with information and with the same level of trust building that we do on the labor rights issues. So there I see a challenge, and I would also see a need for other approaches next to an access to remedy system that are relevant to really make sure that there is an improvement in relation of implementation of human rights, to hold the industry accountable.
Thank you, Mrs. Freeling, for giving us an insight into a very successful mechanism, and also for pointing out again how the engagement at local level is necessary for accessibility. And I also found very interesting your ideas on how to ensure transparency and accountability, and that is something we should discuss. But unfortunately, we don't have much time. The clock is ticking, as we can see very well on the screen. We have now Mr. Quiros joining us, and we can now see him on the screen with the clock in the background. So hello to you and welcome. As I already said, you are working for the Scottish Human Rights Commission, and we would like to ask you to elaborate, but very briefly, if possible, on the role of national human rights institutions in accessing remedies for victims. Thank you, Mr. Quiros, you have the floor.
Thank you for bearing with me. I welcome the opportunity to speak to this session on behalf of the European Network of National Human Rights Institutions, which is a core group looking at the issue of climate crisis and human rights, and the membership is both not only European but global, from the global south. So I will briefly discuss with you the state of where we are and some examples of NHRI work. For those who do not know, NHRIs are independent national bodies which are established by legislation to promote and protect human rights. And NHRIs have a very valuable and unique role to play where climate and human rights are concerned. In the last decade, NHRIs have been using our advocacy, policy advice, investigation, complaints powers, and ADR procedures, as well as supporting human rights defenders as core issues in this area. As a group or individual, NHRIs are increasingly engaging on environmental damage and human concerns, concerns related to human rights, of course. For example, in 2015, the Commonwealth Forum of NHRIs adopted the St. Julian's Declaration on the role of NHRIs on climate justice. which is the element of remedies. And in December 2020, the Global Alliance of NHRIs adopted a statement on climate change. As individual NHRIs, the focus has been on a number of concerns and actions. For example, supporting right holders who are negatively impacted by climate change via monitoring and reporting, and sometimes using ADR and procedures as well. So the Honduras Comisionado Nacional de los Derechos Humanos has examined the impacts of drought on food production and security in 2016, and they documented the effect on smallholder farmers and called the government support to build the capacity to the use of different seeds, growing practices, and market strategies. And it is clear for us, NHRIs, that the most vulnerable must be at the forefront of measures to address climate crisis. So, for instance, the Samoa's Office of the Ombudsman has delivered advice on the international and internal relocation policies of the Samoan government in response to climate change. And the Ugandan Human Rights Commission detailed the effects of climate change worsened drought on floods exacerbated by El Niño y La Niña and the 2017 cycle. There are also significant work on aligning policies and that goes beyond remedy, but NHRIs across the world are working on sustainable development goals, including in Goal 13 on climate action and Goal 7 on affordable clean energy. And this is reflected in the Merida Declaration on the role of NHRIs in implementing the 2030 agenda. So as the link between human rights and the environment is strengthened, NHRIs have also started to work on complaints and investigations which relate both to business and the environment. Importantly, we can bring our learning and experiences with remedy in a business and human rights context to be built on in relation to the environment. So let me give you some examples of this. So the Ombudsman Office in Croatia has engaged on complaints handling on the health effects of air pollution and brought a climate change perspective to that issue. The Mexico's Comisión Nacional de los Derechos Humanos dealt with complaints regarding a proposed coastal resort development in Mexico, which would produce a negative environmental impact. The issue also raised the harassment of human rights defenders, climate rights defenders, which is key for the NHRIs. So the Commission initially issued a protective order to cease the harassment on the human rights defenders and produce a series of recommendations to the relevant federal and local bodies, which were fully accepted. So again, this is a clear outcome in terms of remedy. A landmark process that probably you are aware is the 2015-2020 National Inquiry into the impact of climate change on the Filipino people carried out by the Human Rights Commission in the Philippines. The Commission presented its finding at the 2019 UN Climate Conference, which concluded that carbon measures had a moral responsibility for human rights impacts linked to climate change. There are other examples. For example, the Colombian Defensoría del Pueblo has been monitoring the impact of hydroelectric projects across the country. And they prepared a study that assessed the 8 hydroelectric projects and concluded that the companies have exceeded their environmental operating permits and violated participation rights. We also strengthened legal underpinnings by influencing policy and legal change. For example, the Scottish Human Rights Commission, where I work and I lead this type of work, has successfully pursued the integration of climate justice as a key principle in climate policy, and is co-leading an extensive national process to improve Scotland's human rights framework and expanded it beyond the European Convention of Human Rights to include the right to a healthy environment. And the Scottish Government has agreed to do so in the next Parliament.
Mr. Quiros, could I please ask you to come to an end? Unfortunately, we're running out of time.
Yeah, absolutely. So this, just to finalize, these are a few examples of how we can and are playing a key role not only to enhance access to remedy, but making structural changes to our environmental and legal framework. And I just want to thank you for your time, for listening, and then feel free to reach out to us for questions or explore potential collaborations.
Yes, thank you, Mr. Quiros, and sorry for cutting you short. I think all of us can see that this is a conversation that needs to be continued. This is just the start. I would just briefly give the floor back to Ola Gläser to reflect on one or two of the issues, and also of the perhaps the most important issue that has also come up in the chat is the question of ensuring transparency, ensuring that procedural requirements are respected. There are worries with reference to the discussion going on in international investment law. So if you could address these issues very briefly, Ola, so that we can then go into our well-deserved coffee break.
I will try to be really brief. I agree with the assessment of Madalena Neglia that the existing dangers of using ADR instead of court, and Richard Miran also has mentioned that, are great. And what I have said is not the assessment of the average functionality, effectivity, or even integrity of the average grievance mechanism, but it's rather the attempt to analyze the potential of bringing the benefits to the table, as Margaret Freeling has said, as one piece of a puzzle of changing circumstances towards more sustainability and human rights standards. And so grievance mechanisms could be thoroughly designed and created intersections to the law court. So I see them as a non-judicial twin that should develop and grow hand in hand with the legal protection by the courts and with the material standards. And of course, there still remains the danger of misuse. So especially in enterprises that don't want to recognize their responsibility, or they want to stall and create delay, there should be procedural options to opt out. So there always has to be an exit back into legal proceedings. I think that's really, really important. That's what I wanted to underline mainly. And the transparency has different levels. It has to be transparent for the people who use the process. And there are interesting models from now I have to say, the consumer conciliation practice, how you can use digital tools to make processes transparent for people who use them. But there also has to be accountability via reporting systems. So the public democratic control is not pushed away from ADR. The downstream, I think we don't have time to really elaborate, and Margaret would be the one to answer there, maybe how you can make accessibility feasible downstream in long and intransparent supply chains. But thank you very much. I really think we should continue the discussion to get synergy effects instead of talking about competition between procedural pathways. Thank you.
Thank you, Ola. It hurts to turn you off, but I'm afraid we have to do so. So I'm not going to give a long summary because there are so many aspects that have been touched upon. But I think what has been shown very clearly as about a process, as has been the result of the first panel, in fact. And if we look at the individual grieving mechanisms, I think we should see them as living instruments. That is a saying that I took from the court. So a process with grievance and mechanisms that have to be continuously developed, adapted to the needs of the parties to the case and the problems we are talking about. The final question that we don't have the time to deal with is, what is the role of the Council of Europe in this context? And the presentation of Ola Gläser has given some indications about having perhaps a non-judicial twin of the European Court of Human Rights for business and environmental cases, or using the Council of Europe as a sort of clearing organization that ensures quality standards for non-judicial mechanisms. These are just two ideas that were presented, and we need to reflect on them and have further discussions. But unfortunately not today. Thank you to all the speakers and panelists for really passionate and interesting conversations, and we will reconvene after a very short coffee break at 10:45. Thank you.
Yeah, this is very nice. Thank you very much. I hope we still have a good number of participants. I was just checking some technicalities. I'm Daniel Klein, the moderator of this third session, which will be a bit longer than the first and the second session of this workshop because we have a larger number of in the panel. And after having heard this morning on the nexus between human rights and business responsibilities, with various perspectives from the global level as well, and then the second panel on effective remedies in particular, we want to dive in now a bit deeper again into the business perspective. So what is the concrete business environmental responsibility today and in the near future? And we will also hear what can the Council of Europe contribute. So the purpose of this third session is twofold. First, it will look through the lens of the private sector and ask how businesses can implement environmental due diligence. And we'll hear about that from our speaker from a government agency. And then the session will engage directly with business representatives in order to better understand their activities and initiatives. Corporate social responsibility, or also environmental social governance, ESG, incorporating the environmental and human rights dimensions in business operations. In this respect, we will hear from the perspectives of a large transnational corporation, but also from one of the UN Global Compact's national networks, as well as from civil society, including experience from international law and environmental litigation. The second objective of the session will be to highlight several of the Council of Europe's activities, which could offer support to businesses to better understand, identify, and address the links between human rights and environmental related risks and challenges, and which can strengthen their capacities to actively contribute to addressing the global environmental challenges of our time. In particular, we will focus on the Council of Europe's Social Charter and hear also from Council of Europe staff on activities seeking to promote business practices which integrate corporate social responsibility with regard to human rights and the environment. So let me move to introducing the speaker and the panelists. We have one speaker and 5 panelists, as I mentioned. Dr. Bettina Rechenberg from the German Environment Agency will be our speaker. And then we have the 5 panelists, Mr. Thorsten Pinkepank, Director of Sustainable Relations from BASF, Laura Kurze from the Global Compact Network Germany, Professor Hermann Ott from Client Earth, Jan Malinowski, Executive Secretary of the European Social Charter, and Tigran Karapetyan, Head of the Unit Cooperation Programs, DG1 of the Council of Europe. Before I give the floor to Dr. Rechenberg, I want to give some practical information. Maybe you have followed the first sessions, then you know that already, but maybe you haven't. So regarding running the session, after the panel, we will open the floor for about 15 to 20 minutes, hopefully, or even more, of discussion and questions and answers. So if you have questions, as before, please be prepared to either take the floor. I'll be able to see requests for the floor, or send the questions via the chat box. And the Secretariat in Strasbourg and our colleagues in Berlin will hopefully help me to watch the list. And I will do my best to keep the time. Yeah, the speakers later, the panel will have to always click request the floor. But for now, it will be just Bettina Rechenberg. Please, just a heads up, never push release mic. At that moment, you will be thrown out of the floor. So instead, when you speak, unmute your microphone, and when you don't speak, please mute it again. So you can already see Dr. Bettina Rechenberg. It's a pleasure to have you with us. You are the Director General of the Division Sustainable Production and products and waste management at the German Environment Agency, Umweltbundesamt in Dessau. You are a biologist and you worked at the Umweltbundesamt already since 1992, gaining experience in chemical safety, water protection, sustainable production, resource conservation, and material cycles. I understand that more specifically, you are engaged in the analysis of environmental impacts or effects linked to raw material extraction, industrial production, consumption, and waste management. And you're searching for sustainable and practical solutions. So we are pleased to have you with us. Please release your microphone, and I understand that you would manage your presentation from your side, yes? Over to you.
Thank you very much for the nice introduction, and distinguished members of the Council of Europe, dear ladies and gentlemen. Thank you for inviting me for the workshop. It's an honor to give the keynote here. And in my keynote, I will take a look on the need for environmental due diligence processes in companies and how these can be implemented in practice. So we already heard this morning that the current state of the global environment is worrying. We urgently need further and more ambitious action to solve the lingering environmental crisis. The United Nations Global Environment Outlook showed that we are not on track to reach the environmental dimension of the SDGs. Climate change, mass extinction of species, land degradation, and the list goes on. In consequence, we need to act fast because the window for action is closing. And we need to act together. All societal actors, including businesses, need to make their contributions to solving the environmental problems. Due to their imports, exports, investments, and business relationships, developed countries and their industries are closely connected with these global environmental challenges. Their negative environmental impacts predominantly occur in global supply networks. Taking, for example, the German automotive industry, around 25% of greenhouse gas emissions relate to direct suppliers, 55% to the production of input materials, and 10% to the extraction of resources. For retail,
one interruption, Ms. Reichenberg. Are you willing to show slides at the same time, or if you allow me, I can also manage it from here if you prefer.
Okay. In my screen, I see the slides. So
I don't see them. I don't know whether the audience sees it.
Okay. So maybe it's better you manage it.
In the right icon, there's share screen. If you try again, maybe.
So thank you for this advice.
Yeah, sorry, I was listening. So.
So it's.
So, do you see it, or shall I do it?
Do you see some slides now?
No, can't see it. Anyone in the Council of Europe can see the slides? No. Then I would.
So maybe you can
try this.
Click for me. Okay, I can see it.
Okay, I can now only see the slides and no screen anymore, but if that's fine for everyone. Yeah.
Yeah, okay, then we go with the slides. Please go to slide 3.
Yeah, this would be about the examples from the German automotive industry.
Exactly. So
yeah. Sorry for that. Yeah.
No, thank you. It was a really fruitful and important advice. So if you have a look to slide 3, you can see that round about 25% of greenhouse gas emissions of the German automotive industry relate to direct suppliers, round about 55% to the production of input materials, and around about 10% to the extraction of resources. And for retail sectors such as food or textile, the share of environmental impacts in the supply chains is even higher. Consequently, it is imperative that policy and business action for environmental protection is also directed towards impacts in global supply chains. Next slide, please. So the due diligence is a promising concept to promote business action for respecting human rights in supply chains. From a company perspective, due diligence is a risk-based management process that includes identifying and assessing adverse impacts in own operations and along the value chain, taking action to seize, prevent, or mitigate the impacts and risk, and tracking implementation, evaluating results, and taking further remedial or preventive action, and publicly reporting on the outcome. Next slide, please. And even though the concept was originally designed for human rights, it is also applicable to environment issues. So we see that the due diligence process as such is generic and can be tailored to the context of the company. If you go to the next slide, please.
Just a second, we are still, the slides don't change. I'm so sorry. On my screen it did change. So let me try to share again the screen. I went on presentation, so you see it bigger, but it seems that it was not working.
Ah, okay. So maybe we can use this kind of presentation. And if you go to slide 6, I think it would be better than seeing no presentation. So the due diligence process, yes, and we see we can adopt it also to environmental issues. And next slide, please. Okay, meanwhile it is widely acknowledged that a healthy environment is a precondition for the enjoyment of various human rights. It is because of this link that environmental damages can also play a significant role in a company's human rights due diligence process. This is, for instance, the case for the pollution of water and soil from a major incident, such as a tailing dam failure, destroying the livelihood of people by making the land inhabitable, compromising the drinking water supply, fishery, or agriculture activities. And in this regard, we see environmental due diligence process as a logical synergy, but also as a necessary complement to human rights due diligence. Going through the process of environmental due diligence will allow a company to identify environmental hotspots in its supply chains that would perhaps not, or too late, be discovered with a sole focus on human rights impacts. So from our perspective, environmental due diligence process can reduce also the risk of human rights violations. And human rights and environmental impact ensure that connections, synergies, and gaps between the two become apparent and can be handled without promoting one on the expense of the other. Currently, we observed various political initiatives. You can see this on that slide, and an increasing number of laws that aim for legally binding corporate due diligence. Most important, probably the initiative of the European Commission. And the trends towards legally binding requirements is not surprising. It is because of the fact that voluntary approaches have proven to be insufficient in tackling the pressing environmental and social problems in global supply chain. On this slide, you can see an example of Germany, a representative survey among large companies. This survey shown that 85% of them have not implemented processes for human rights due diligence on a voluntary basis. Looking at the reporting of German companies under the European Non-Financial Reporting Directive, we also find significant gaps. 46% of the companies provide basic information on their supply chain structures, but only 9% include information on sub-suppliers, and only a fourth reports on high-risk supply chains. This is why civil society organizations, but also a considerable amount of businesses, call for a level playing field and legally binding human rights and environmental due diligence requirements. Next slide, please. Okay. Next slide. Yeah, so we now, no, one slide back. Thank you for the assistant, Daniel. When we now think of making environmental due diligence legally binding, it is important to design it in a way that avoids mere box ticking and compliance exercise. It is clear that just conducting and documenting the process is not sufficient to prove that the company is not responsible for an environmental damage or human rights infringement. This is why the due diligence process as such is an important but not the only element of a broader duty of care. It will be important to add substantive standards that specify the level of environmental protection, and in case relevant multilateral environmental agreements are at hand, they should be referred to the legal text, and it could also be specified by a reference to the environmental law of the home state of the company or the law of the host state, or a reference to the best available techniques for a specific business sector. And in addition, there should be some form of civil or administrative liability for environmental damage. I think we heard about. So next slide, please. The considerations for business praxis. Next, yeah. Let us take a look back at the company level. What should companies consider when they implement an environmental due diligence process? The first important message I want to convey, especially to those businesses that may think, oh, this is all new and something completely different than before, you are not starting from zero. Companies can very well build on existing processes and structures that are already in place. And secondly, by all means, avoid silo thinking and isolated organizational structures. Environmental and human rights impacts in supply chains should be analyzed in their own regards, but addressed together in an integrated way. And finally, I think it is important to make practical experiences, cooperate with others facing similar problems, and share achievements and mistakes. So next slide, please. how to address human rights violations and conflicts related risks has been taken up broadly in due diligence guidance and company practice in mineral supply chains. However, even though serious environmental damage from the mining sector is well documented, sector-specific practical guidance on environmental issues is missing so far. So in order to fill in this gap, the German Federal Ministry for Environment has initiated an international process to develop an international practical tool on environmental due diligence in mineral supply chain. And we, the German Environment Agency and the Federal Institute for Geosciences and Natural Resources are supporting the Ministry of Environment in advancing this initiative in close collaboration with the OECD Center for Responsible Business Conduct. And the tool, which shall be developed in a participative multi-stakeholder process, shall describe how the 5-step generic due diligence framework recommended by the OECD can be applied to environmental risk and impacts in global mineral supply chains by providing approaches and best practice examples. It shall support on ongoing environmental risk assessment and management and describe how environment-related risk intersect with human rights. And this process at the OECD over 2021 to 2022 was kicked off yesterday. So coming to my conclusions, next slide, please. We think that the due diligence processes are a very promising business and policy instrument as a part of a broader policy mix for protecting human rights and the environment in global supply chains. Other instruments such as international trade agreements, development cooperation, or broader tax adjustments must be pursued in parallel. It is again very important to mention that mandatory human rights and environmental due diligence process must not be understood as a carte blanche for businesses. They have to be designed in a way that they do not undermine existing obligations and liability mechanisms for businesses. And substantive internationally recognized environmental standards are often still missing, and we think they should be developed with priority. Here, the Council of Europe could also play an important role. From a business perspective, it is worth to repeat that most, they often do not start from zero. Last slide, please. Ideas for the contribution of the Council of Europe. I think if the Council of Europe seeks to develop practical guidance for businesses in its member states, we recommend a close coordination with international organizations already active in the field, such as the UN, OECD, and ISO. And it will be important that guidance is international aligned to ensure coherent expectations from businesses. The Council of Europe could consider an initiative that encourages value chain legislation for human rights and environmental protection in member states. And last but not least, to address the problem of a missing internationally acknowledged standard as an anchor point for environmental due diligence, the Council of Europe could foster consensus on minimum environmental protection standards that businesses have to promote in their supply chain. So thank you for your attention, and Daniel, thank you very much for your assistance.
Thank you very much, Dr. Rechenberg. Yeah, you should have chosen a technically more versed assistant, because for me it's the first time with Kudo. I know a couple of other systems, and whenever I see you on the slides, I don't see the chat. When I click on the chat, I'd see not very much. So thank you very much. I would immediately now invite the panelists to join me here by requesting the floor, or requesting to be added to the platform. We will have 5 panelists, as I mentioned, and I think they are appearing one by one. I will introduce each of you once I give you the floor, because we are tight in time, particularly now with me managing the technicalities. And I would be happy if Dr. Rechenberg can stay as long as possible. We know you will not be able to still stay to the very end. So let's, without further ado, first move to our first panelist, intervening by Mr. Thorsten Pinkepunk. On my screen, it's on the left side here. I hope you can all see. Yeah, Thorsten Pinkepunk. Oh, sorry, now I lost I lost something here. I'm sorry. Is the Director of Corporate Sustainability Relations at BASF. And after completing his education in business administration and studying political science and mass communication and psychology, he helped in establishing a political and business consulting institute. Then there he developed and moderated projects on sustainability issues on national and local levels for business and politics. And since 2002, Thorsten Pinkepunk is now at BASF, and he has held various positions in political communications. And he then headed the Human Resources Advocacy and Communications Unit before taking over responsibility of BASF's corporate sustainability relations. But he has not only been active in the BASF. From 2012 to 2017, Thorsten Pinkepunk was a member of the GRI Stakeholder Council, and he's chair of the German Global Compact Network, from which we will hear also from the second panelist, Laura Kurze, afterwards. He's member of the board of CSR Europe and of EcoSense from Sustainable Development of German Business, and is also a member of the expert network of the UN Global Compact. And I would like to kick off your intervention with a question, a very practical question, Mr. Pinkepunk. What is your company doing to implement environmental social governance, or short ESG? And also, having listened to the keynote presentation of Dr. Rechenberg, would you agree that voluntary standards alone will not be sufficient to achieve environmental protection and realize our SDGs? What is needed from your experience, from your perspective, please?
Yeah, thank you, Daniel. Can you hear me properly?
Yes.
Okay, great. Great. Yeah. Also, my first time with Kudo, I have to admit. So we are all working on that, I guess. Yeah. Thank you so much for having me. Thank you. I appreciate to be here representing, to some extent, business. And thank you, Bettina Rechenberg, for your introduction. You asked me to answer the question: what does BASF do, and what my perspectives on the keynote were? Maybe starting with the keynote. I can agree to most of the things, Bettina, you've said. I mean, for sure. I mean, we are all clear about the close interlinkages between the different dimensions of sustainable, social, environmental, economic, and for sure also environmental and human rights topic. They're closely linked. That's clear. I mean, therefore they are basically also specifically in the chemical industry and also at BASF, both integrated in audit schemes like Together for Sustainability, also for sure in our code of conduct. I also like the considerations. For sure, the devil sometimes is in the detail. How and how we can really shape and design mandatory due diligence schemes. What does it really mean on the ground in practice? But I specifically like, by the way, your your thinking around the sector-specific guidelines, and that I can elaborate maybe in a minute on that also, because we are quite engaged currently in the mining part when it comes to batteries, because that is for sure a topic where these two things come together. Then you asked me, what is BASF doing in terms of mandatory or due diligence in terms of ESG, environmental, social governance? I would give two maybe examples. First of all, and because that is also currently maybe the main point of the discussions in mandatory due diligence, is what we are doing along the upstream supply chain. And for sure, what I see in our due diligence here is that our maybe two main ideas around that is a risk-based approach and a partnership thinking. So what do I mean with that? I mean, when it comes to our, let's say, risk analysis in the supply chain, for sure we think about things like the origin of the things we source, and for sure also the industries we source from, and also for sure that is put into data banks, and we here guide all this steering when it comes to risk assessment on a risk-based approach, for sure, because it's different whether you source raw material from a non-OECD country than whatever services maybe from you. I guess that is clear. The second thing, because that's also important to me, is this partnership thinking in two ways. First, years ago, the chemical industry invented a joint venture, so to speak, called Together for Sustainability. That is a platform and a corporation of currently more than 20 companies in the chemical industry, and they have come up with the idea of one audit of a supplier is an audit for all the members. And so to have really a partnership here and to really share and the data here, and that is, I guess, basic thinking here, and also to think, okay, we need to partner in a sector on this topic. A second idea of partnering is also here, we need to see our suppliers, not only of objects we need to steer, and objects we need to check and control, but also partners in terms of innovation. Very often we need our suppliers, which are to some extent also our customers, by the way, as partners for innovation, not only in methodological things like supply chain due diligence, but also in really terms of innovations for sustainable development. For sure, also many companies and also BASF, we have clear targets here when it comes to how many suppliers we want to assess, how many suppliers we want to audit, how many suppliers we want to see improvement in what kind of time phases, and this is all done in a kind of specific systematic approach. We do have a specific unit only in supply taking care about that, and for sure we are very clear in terms of publicizing our expectations and asking our suppliers in terms of expectation. We do have a supplier code of conduct for sure, based on things like the United Nations Global Compact, United Nations Guiding Principles, IDO standards, and we are clear about what we are expecting from our suppliers here, and that is in, I guess, more than 12 languages, around 12 languages. And at the end, there are also rules on how and what kind of time phases and what kind of improvement we want to see from our suppliers. And the last resort, the ultima ratio, is really to end business, but really the ultima ratio, because as we see, we want to see our suppliers developing. Coming from supply to maybe the sites, and the environmental topics are also closely linked to our sites and our products, for sure, not only to supply. We have since years, and I guess 30 years now, it's an anniversary this year, of a management system called Responsible Care. That is what the chemical companies are doing in terms of the due diligence process when it comes to transportation, when it comes to their operations on site, but also when it comes to the customers' applications of our products. And these are connected to binding directives at BASF and binding directives at many other chemical companies also. We have clear standards here, and we for sure do audit them. We have about plus 100 audits each year, and we normally audit our sites in a mode of 3 to 6 years here to have a look whether and where we have issues and what the improvement has been and the communication and progress is here. Just to give you a flavor, we invest, we have costs at BASF.
That you come to the last minute, sorry, Mr.
Okay.
Oh, yeah.
We have costs at BASF about 1 million of environmental topics here, environmental safeguarding here. Let me at the last minutes maybe just think about three messages here. When it comes to where we agree on many of those things, Bettina's also said, but we really need to understand the complexity of the value chains, because they are normally not value chains, they are value nets. And that is really important. It's about structures. It's not about a linear system of a supplier and a customer. So in many cases, we have structures here, so we must not underestimate the complexity. And therefore, it's really important that we are very clearly about the things we expect from companies when it comes to due diligence in terms of appropriate tools and mechanisms, and we need to clarify what appropriate, proportionate and means here and feasible means here, and therefore that's a second wish from my side. We need to think in corporations. We need to organize corporations, and basically, and most importantly, also on a sectorial level. Yes, we need more than one sector, cross-sectorial initiatives like we do on the battery scheme, for instance, with the Global Battery Alliance. But we also need to bring down the mandatory due diligence and the due diligence tools and procedures on a sector-specific level, because there's a place where we can clarify and clearly articulate what really the proportionate tools and actions of a company could be. And for sure that we are currently doing in Germany with a initiative called Chemistry by 3. This is an alliance about the associations and the unions together, and we are about to develop here something like standardization for a sector when it comes to these questions here. So the last important thing for me is, and I would welcome what Bettina said, and in terms of the smart mix. For sure, we need a mix of mandatory and voluntary things. And very important is that we have to differentiate between the first rugby pillar and the second pillar. We must not delegate state duty to protect to the private sector, but we need to be clear here, but we need to have a clever mix, and not only a smart mix, but also a smart discourse. And maybe, I guess, UN Global Compact, for instance, the German Global Compact could be a good platform for organizing this smart discourse, because that's a process we are proud to join. It's not a kind of first thing. We will not solve the issue with a law, not on a national level. We are more for an international setting here. I also agree with Tina that we need to come to an international standard here. So hopefully to be in the 5 minutes and touched upon a lot of things, maybe we can deepen that in the discussion.
Oh, sorry, I was not.
You are muted.
Yeah, thank you very much, Mr. Pinkenbang. It was honestly quite a bit above the 5 minutes, but that's my responsibility. I thought it was just very important to hear your practical examples, but we will come back to that question in the first panel that I have also followed. Professor Deva and also Carlos Lopez from the International Commission of Jurists said, well, this mix has actually failed, and we have too many voluntary components in that mix, that not enough binding. I think everybody agrees that the mix, there must be a mix, but they must be truly complementary, and we want to know what works and where do we need to get in with legally binding. But I like that we see this in the global context, and that's also why I'm happy to have someone from the UN Global Compact with us here. It was looking like we would not have a person, because Laila Karbasi is from the UN Global Compact in New York, had to drop out on short notice, but we could find Laura Kurze, who is from the German network of the Global Compact. And I'm very grateful that you stepped in this short notice. You are the Director for Business and Human Rights at the Global Compact Network Germany, which many may not know is among the oldest and the largest local networks of UN Global Compact, more than 600 participants from business, civil society, and public sector. And you have been very active in raising awareness and supporting companies. Yeah, it's your role to coordinate the activities of the global network and support in practical manners how these particularly the principles, the UN principles, are translated into business practice from the human rights perspective, but many of your experience will be transferable also to your environmental problematique. So over to you, Laura. Thank you very much.
Thanks so much for the kind introduction, Daniel, and also thanks to the organizers from the German Chairmanship and the Council of Europe for having me. As you've heard, I am not an environmental expert, and I also joined at the very last minute. So with these caveats out of the way, let me try and share some thoughts on today's topic and also pick up perhaps on some things that have been said already. You already introduced the German Global Compact Network, Daniel, so I don't really have to do that anymore. Just maybe a few words. So we are a network of around more than 600 German participants of the UN Global Compact, comprising a lot of companies, mainly companies from all sizes, all sectors, but also non-business participants from civil society, academia, etc. Our mission really is to assist, in particular, businesses in implementing the 10 principles of the UN Global Compact, which I assume most are familiar with, as well as to mobilize business contributions to the SDGs, and also to facilitate a multi-stakeholder exchange really on these topics. Of course, and we've heard that as well, human rights, environment, and governance issues are all linked. Sustainability is multidimensional, and I think responsible business conduct also has to be reflecting this reality, really. And that's why the 10 principles of the UN Global Compact also cover all of these issues, right? They participating companies commit to respecting human rights, but they also commit to preventing environmental damage and take efforts against corruption in all its forms. So really do no harm across all of these dimensions. What exactly this means, and you asked me ahead of the panel to perhaps discuss a little bit what we do in practice. What this means, what these principles mean for each company will be different depending on its size, on its sector, on its operating context, on its business model. It will be different for BASF than for a construction company or a telecommunications provider. And what I do, for instance, in my day-to-day work is especially two things. So on the one hand, build German companies' capacity to find the answer to what this approach means for them specifically, to conduct human rights due diligence in line with the United Nations guiding principles. And secondly, to provide a platform for exchange, not only amongst companies, but also cross-stakeholder, which we believe is really essential if you want to have due diligence processes that not only look lovely on paper, but in particular that help generate actual positive impact on the ground. And we do the same with regard to the other areas, topical areas that are covered by the UN Global Compact 10 principles and the SDGs, of course. You also asked me yesterday about some implementation challenges, and I would actually like and turn that on its head and perhaps try and reflect on some factors that I believe make due diligence approaches, in particular with regard to human rights, successful, both in the sense of effectiveness, but also in the sense of credibility, which I think is an important topic as well. So first of all, it's really maintaining a focus on outcome and actual change. I already alluded to this. I'm highlighting it again because I think it's very important that companies do not lose sight of what is it that they actually want to achieve with a given due diligence process. We heard about risk-based approaches. What's the risk that we actually want to address? And what's the change in the situation that we do want to see or that we do want to contribute to through our processes? I think this is also important to help navigate an increasingly complex and fastly evolving and dynamic political and legal context. We heard from Dr. Rechenberg about the planned due diligence legislation in Germany. We heard about the developments at European level. I think a focus on impact, on the change that we want to see can also in a way help navigate this. Secondly, I think it's being open to dialogue, being committed to transparency for businesses and engaging stakeholders. And on that last point, not only with regard to learning from one another, or not only for the sake of engaging, but really also because we have to acknowledge that there's lots of topics that are so complex in nature that not one company alone, also not several companies together, will be able to address the root causes sustainably and effectively. So there are issues where it is possible, there's other issues where it's not possible, and where we do really need that collaboration in order to address them. Thirdly, and that's also been picked up by both my previous panelists, I only want to add a few thoughts on the conducive environment. And the smart mix, obviously, it's been a buzzword for a couple of years now. It still remains somewhat elusive, I agree. But then again, I think we're at a crucial point in time now where we do have concrete plans with regard to the mandatory dimension that actually give us a great opportunity to discuss what the other dimensions will have to look at, what will have to look like, what different actors' role can be in really defining and designing a smart mix that generates impact. It's one important thing to raise the floor by setting minimum standards, but then we also need to think creatively about and really to encourage a race to the top. And we have had and are having these discussions, obviously, and also our activities at the German Global Compact Network, our conferences, etc. And I see the timer at the top. Yeah. I'm getting to my last point. And I just wanted to take a step back and just also encourage to, and that's very easily said, but see the big picture. And what I meant by this, all of these things are linked. We all know it and we all understand the linkages. But what we really need to get at, and Dr. Rechenberg alluded to this in her presentation as well, and really made the case for it, is linking them where possible in business practice. We do see this quite a lot already with regard to anti-corruption issues and human rights issues, for instance. I think this is also something that we start seeing more and more, and also encourage with regard to environmental issues and human rights issues, especially where these linkages are very direct, such as with regard to access to water, hazardous waste, etc. You had some examples in your presentation as well, Dr. Rechenberg. But it's obviously less straightforward with regard to globalized issues, such as climate change, in the sense that it's very difficult to link impacts on loss of livelihoods as a result of climate change back to the specific emissions of one company. And Surya Deva made this point much more eloquently than I can this morning. And now really my last point, but putting these conceptual questions aside for a second, I do want to underline that the UN Global Compact already now encourages businesses to adopt a principles-based approach to sustainable development and to the SDGs in particular, that takes into account all of these dimensions, and that basically says, yes, we need business contributions, we need business investments, innovations in order to achieve the SDGs, but we need them to do these responsibly. So do no harm first, and then provide solutions to societal challenges. I think that's a really important point. And while I do think that the question of, how exactly do we integrate human rights and environmental due diligence in practice, in policy and in business practice? So various
sorry, but Laura, yeah, thank you very much. I think we need to come to an end.
Okay, just wanted to say, happy that we're discussing this today and happy to be a part of it.
Yeah, I'm really sorry, but we have, just to be fair to the others, it was a very rich contribution. I think the next panelist will also take up that point very thankfully, that it's both about minimum standards, but also raise the floor and raise ambition towards and create front runners that really help us to get as fast as possible, particularly if I think of the climate change crisis, which I have been working most of my professional life on, and that Professor Dr. Hermann Ott has been working also most of his professional life on. He has had many hats, including on the Wuppertal Institute for Climate, and has been even a member of the Bundestag earlier. But most importantly, most recently, he is now the founder and managing director of the Germany office of Client Earth. He's, of course, a lawyer, PhD in international environmental law from Berlin, and holds a professorship at the University for Sustainable Development in Eberswalde near Berlin. So, Professor Ott, could you share your perspectives, both as a lawyer, but also as a representative from civil society, on these questions that have been raised: binding versus non-binding instruments, national level, supranational level, international level? Where do we need to prioritize our and focus our energies? And yeah, how to best advance environmental due diligence in business practices in such complex things as the value change or value net, as Thorsten Pinkelbank has called it. Over to you.
Thanks, Daniel Klein. I hope you can hear me clearly. Thank you. Yes. Well, thanks to the Council of Europe, to the German presidency for this event, and especially for bringing human rights and environment protection together. Something which was not to the extent possible in the German supply chain law that's just with Parliament at the moment. But thank you, Bettina Rechenberg, for pointing out that the close interlinkage between human rights and the environment. Basically, there is no protection of human rights in a bad and disturbed natural environment, because that's the precondition to enjoy human rights like health and a good life. Usually you're used to Client Earth being more on the litigation part, and that's a very, very important part of what we're doing, holding companies, holding government agencies accountable for their actions if they are polluting the environment. And that's what we're also doing, not only for specific acts, but also in order to advance the law, because that's, I think, what's happening at the moment. Holding companies and enlarging the concept of due diligence, enlarging the concept of managerial responsibility and, I must say, liability for actions of their companies and authorities. But of course, a great part of that is also legislative action, and that's what I find here and what I find so important. And I would like to focus on the question, what's the role of the Council of Europe in all this? Because if you think of it, there's a lot of activities on all levels. I mean, we've got the national level with the supply chain laws, just alluded to it. We've got the European level. We've got the United Nations level, and thanks, Laura Kurze, for introducing us to the important work of the Global Compact. We have legislative, or we have rule-making on various levels, from the non-binding codes of conduct to specific legally binding obligations for companies, let's say. And so what's the role the Council of Europe can play in this? Well, on the one hand, I think one of the advantages that the Council of Europe has is the very, very clear connection between human rights and the environment and environment protection. And not to say the least, binding, setting binding regulations, binding rules. I mean, especially the European Social Charter, and we will hear more about that, has very clear rights. For example, the right to safe and healthy working conditions, the protection of children from physical danger, the obligation to remove causes of ill health. Quite a lot of very specific regulations on which any further due diligence process can build and should build. That's really an advantage that the Council of Europe can bring. And I'm really looking forward to Mr. Malinowski and all the endeavors at that level. Second, there is a long history of and a tradition of making binding rules in the Council of Europe, and that's very important if you look at it. We've heard about the mix. Thorsten Pinkepank has mentioned it. We've heard from Laura Kurze that we've had so far a mix, but a kind of a too large proportion of non-binding parts of that mix, and that we need more binding parts. And I think that's the experience. And maybe in the discussion later, Mr. Pinkepank, you can respond to that. But I think if we listen to business, if we listen to what companies want, it's all the time the same. It's clear rules, and it's the same rules for everyone. That's the basis for making business. And that's, I think, could be one of the important roles of the Council of Europe, because, and that's my third point, because of the membership, of the wide range from the core European countries to the Ukraine and Russia on the one hand, and nowadays we must say to the West, the United Kingdom is also part of that. And that will allow, and that's not only a common geographical space, it's also a common economic space. And that's where companies engage in business activities. And that's why it is important that there is comparable rules in this really, really large, the largest probably economic space. So this is an asset that the Council of Europe actually have. And it might also reflect back, my last point, in the history of environmental lawmaking, this has also served to a large extent, in some important cases, to bring partners together who have very diverse views and policies. Think of the Geneva Convention on long-range transboundary air pollution, which brought together East and West. Think of the Barcelona Convention, which brought together and still brings together very different partners from neighbors of the Mediterranean Sea. And here also, in the context of the Council of Europe, environment protection, providing a level playing field for business in this economic space, can also support a core element of the Council of Europe, and which is the human rights, and making sure that in all member states, human rights are being obeyed. So a clear advantage, and I would encourage the Council of Europe to continue and really set some binding legislation here. Thanks a lot.
Thank you very much, Hermann Ott. That was a good round and overview, and also bringing the threads or the dots together, already pointing to some points that we may come back later. Just to inform participants that our speaker, Bettina Reichenberg, will have to leave at 1 o'clock. So you can already, if you have some questions directly addressed to her, also put this into the chat to me. I will see them. I would take one more panelist now and maybe have a short break for any questions then before we have our last panelists in the end. But the next one is Jan Malinowski, Executive Secretary of the European Social Charter. And you have been head of that department since July 2018 of the Department of European Social Charter. And earlier you were the Executive Secretary of the Pompidou Group, the 2014 to 2018, the Council of Europe's Drug Policy Cooperation Platform. And earlier you also served as the head of the Information Society Department and head of Media Division. So from your perspective and your long-standing experience, Mr. Malinowski, with the European Social Charter, which, as most participants will know, it's a 60-year-old human rights treaty that focuses on the social rights. Could you elaborate a little bit on the links, again, between environmental and social rights and the opportunities already mentioned by Hermann Ott also, that the European Social Charter offers, obstacles that you see, and possible ways to overcome them from your experience? Over to you, Jan.
Yes, thank you very much. I have the impression that my space has already been covered by some of the previous speakers on a number of counts. First of all, I would like to say that under international law, the duty bearer is the state. So international organizations have an eye on states, and this is our main interlocutor in this respect. Of course, we do engage with other stakeholders in different ways, but the human rights duty bearer is the state. And voluntary, that means voluntary is not enough. The companies taking on voluntarily responsibilities is very important, of course, but it won't be sufficient. Now, the link between social rights and the environment, it is very clear. There is no environmental provision in the social charter at this stage. We will see in the future, but for the time being, it is not there. There is no autonomous right in respect of the environment. but the European Committee of Social Rights, which is the monitoring body or the body entrusted with monitoring under the Charter, has engaged with environmental issues on a number of cases, on a number of occasions, in respect, for example, of brown coal mining in Greece and the impact on the environment and the impact on the health of workers. It has engaged in respect of the clean water supplies in Bulgaria and in a number of other countries. It has looked into regulation concerning nuclear energy. It has set general standards as well in respect of many of these things. One of the previous panelists representing the International Federation of Human Rights organizations was the applicant in a collective complaint against Greece in respect of polluted water. And that shows how it can be a tool that civil society and other organizations can reach into. But I would like to put it very bluntly. What is the link? If you think in big terms, if you think the pandemic that we are living through now, this is the result of climate change. The scientists tell us that this is the result, indirectly, of deforestation. Scientists also tell us that it is the result of the failure to protect protected species, to apply regulations that existed. So the impact, the result has been, for the time being, more than 3 million deaths. This is a human rights impact, with close to 150 million people ill of the disease. This is a clear social rights and human rights impact. We are talking about, in terms of deaths, 1 in every 2,700 people in the world. In terms of ill people, we are talking about 1 in every 60 persons worldwide. And it does have an impact on business. You know clearly that the business environment had to slow down and was prevented from getting on with doing business. So there is a vested interest in or for business to respect environmental constraints and needs. The food industry is a clear problem in environmental terms and in affecting biodiversity. Air pollution brings about 800,000 deaths or premature deaths in Europe. So it is very clear. Climate refugees are already an issue that many countries have to deal with. And in the future, we are told that there will be tens of millions of additional poor people as a result of climate change. So the issues are there. The link is very clear, and I won't go into more details in that respect. The question is, what can we do about it? What are the opportunities that the Social Charter has? As I said, there are, and as Herman said, there are provisions of the Charter that can be used in order to ascertain, in order to affirm social rights in the environmental context, like a healthy and safe working environment, like the right of children, like the right to health. And there are tools in order to do that. And the Committee of Social Rights monitors the performance of states. It accepts collective complaints in respect of these things. I am going to post on the chat a question or part of the questionnaire that was circulated to member states for the conclusions 2021, which includes references to environmental issues. There are, of course, obstacles to this. There are problems of lack of engagement of states, of even obstructing the procedures and the system that we have in place. The collective complaint system has been accepted only by 15 of the Council of Europe member states, and not all provisions have been accepted by all states under the Charter. But the future can bring about additional opportunities. We could have a standalone environmental right under the Social Charter. We could have a binding, an obligatory collective complaint procedure under this or in connection with this right. As Ms. Sigrid Jacobi said at the beginning, it is necessary to empower rights holders to exercise and to assert their rights. It is incumbent on the state to enable those procedures, to enable that mechanism in order to be able to assert rights. And the Charter is one of those tools, a good governance tool that provides feedback to states in respect of what is not going on correctly, what needs to be redressed, what can be bettered in respect of the protection of those rights. The advantages of the Charter, I will stop very soon, yes. The advantages of the Charter are, one, that it is not about individual rights, it is about collective rights. And it is about the collective exercise of those rights. And another aspect of it is that it follows the principle of progressive realization. We know that not everything can be done instantaneously. So it is possible to enable through the Charter, because of its particular monitoring mechanisms and the way it engages with the performance of member states in respect of social rights, it is an ideal tool in order to insert, to incorporate an environmental right into it. Thank you.
Thank you very much, Jan Malinowski, for this insights into the Social Charter. I personally think that particularly this principle of progressive realization and combined with monitoring is very interesting. We have also the principle of progression as a key cornerstone of the climate treaty, Paris Agreement. Our next final panelist is Tigran Karapetyan, but with your indulgence, Tigran, I would like to give the floor to Bettina Rechenberg for some final remarks. If it's still the case that you will need to leave us around 1 o'clock. I just asked all the panelists, most are comfortable to go 5-10 minutes beyond the allocated time because it's very interesting and very rich. Would be nice if you can stay on a little longer. And Tigran, hold your presentation for a moment, and I would give the floor to Bettina Rechenberg. I don't have specific questions coming from the chat, but you have heard now a lot of reactions to your presentation. So over to you for a very brief reflections from your end.
Yeah, thank you very much to give me the floor again. And I'm so sorry that I have to leave a little bit earlier. I think all the contributions showed that it is really necessary to have mandatory obligations for the due diligence processes. And what I want to add is that there's also a need to implement the process steps within the processes, the management processes of a company, the decision procedures and the policy, so that due diligence process steps getting really functional. And I also want to add that it is important that the due diligence obligations are linked to existing international agreements like Minamata Agreement for mercury or Stockholm Agreement for persistent organic pollutants and so on, and also linked to agreed concepts like the best available technique standards. And I want to emphasize that the Council of Europe could play an important role to support and foster the process of building these links. For instance, by starting a discussion process on minimum environment standards in the member states, which should be fulfilled, because an international, supranational agreement on the standards for due diligence processes are really necessary. So thank you very much again for the invitation, and I wish you a further fruitful and really interesting discussion.
Thank you very much, Bettina Rechenberg, and also for the presentation. Again, there was the question whether that could be shared. So think about it, reflect of it, whether you would be willing to share the full or parts of the presentation as a PDF maybe through the Council of Europe team later on. Yeah, thank you very much.
Problem. Okay.
That's very kind. Thank you very much. Yes, so the other panelists stay on. We still have the fifth panelist. This is Tigran Karapetyan. He was following all the time from next to the operating team here in the Council of Europe, one of the few people who can attend this in person. Tigran, you worked in the Council of Europe since 2013, and you are now the head of the unit in the division of cooperation programs of the Council of Europe's Department for Implementation of Human Rights, Justice and Legal Cooperation Standards. So you are a lawyer with long-standing experience in leading projects in the field of human rights, rule of law, good governance, democracy, because also prior to the Council of Europe, you led democratization and good governance programming in the OSCE in Ukraine, and you also served as a legal project management expert for various international organizations. Tigran, you are developing new concepts on how the Council of Europe can support the development of business practices which take account impacts of business activities on human rights and the environment. Could you please elaborate on those? And I understand that you have some slides to elaborate on those, so please feel free to share it from your end.
Thank you very much, Mr. Klein, and thanks to all the previous speakers. And while our technicians are actually putting on the slides, I would like to note that given all the super interesting interventions that were in this session, but also in the previous sessions, the concept that I'm going to present now is also likely to live through some changes as a result of this workshop, because there were, I think, great ideas on what can be included in further developing this project's concept. Jan already presented some of the things that the Council of Europe could do vis-à-vis protecting human rights and environment, and looking at the nexus of the two. So one of the I'm still waiting for the presentation to be turned on, but one of the
Have you changed the presentation? Because if it's still the same, I may be able to start it from here.
No, our technicians are dealing with it. Maybe I will just start discussing what's already on the first slide of the presentation. The need for the Council of Europe to actually take an active role in this has already been discussed, and there were some ideas, as I said, on how it can be done. So one of the things to be able to address those needs, and also to address the context in which these needs are arising, the context of global business, the context of essentially businesses exporting, and this is in quotes, of course, exporting human rights and environmental damage elsewhere to other countries as a result of globality of business practices, the need to find solutions to make business practices more transparent and accountable in terms of environmental and human rights, environment and human rights. We are proposing to create a platform in which, voila, can we maybe go straight to slide 2, please? Yeah. We need to create a platform where we would have a strong buy-in from the business and helping business to track actual impact of their practices, and help them create environmental and human rights protection tools that can help them do that. Next slide, please. So the idea is we create a privileged platform for businesses to access the Council of Europe expertise, and this will be a platform which will involve both the states and the businesses. So we will use the experience that the Council of Europe has working with the states in developing new standards, but also will plug in the businesses into the process to have a say in the way these standards are developed, and also to enjoy the expertise, the huge expertise the Council of Europe has in the human rights. The platform should allow not only to create something new, but also to exchange and analyze existing best practices in measuring and assessing the human rights and environmental impact along the supply chains, along the value chains. The idea would be, as a result, to create some practical tools that would allow them to track and account for human rights and environmental impact. And as a result, also to give an instrument to the states, both to sanction, if necessary, business practices which are not compliant, but also to encourage the business practices which are compliant with human rights and environmental standards. Next slide, please. There has been a lot of discussion as to what the Council of Europe can do and should do, and why it should be the Council of Europe to do this. And most certainly this slide probably doesn't cover the entire added value, but I've tried to highlight 3 key areas why the Council of Europe is best placed to do these things. First and foremost, because we do have a model of cooperation that works with that already works with 47 member states, of developing standards that to which the states agree and then collectively try to implement and monitor. We also have expertise, standards and case law in the area of human rights, as well as in environment, and also on the nexus of the two. There are cases in the European Court of Human Rights. There are areas which are covered by the European Social Charter, as was explained. And there are also other standards, including binding conventions, a few of which unfortunately haven't yet entered into force, missing the required number of ratifications. We also have experience in monitoring, tracking, and solving complex issues. There was a lot said about the complexity of the issues of human rights and environment, and how difficult it is to pinpoint a connection between a certain business practice and the global impact, or the impact on a particular group of people. And given the fact that the Council of Europe is working to resolve human rights, successfully working to resolve human rights issues, which are not less complex, and we've managed to develop both monitoring, tracking, and mechanisms to implement standards on the ground. We believe that this experience can be transposed to in fact also provide solutions to problems on the nexus of business rights, business, human rights, and environment. Voila. This is the concept that was presented. As I said, based on what I heard today, there's definitely a lot that can be added to this concept to enrich it and make it more substantial. Some of the ideas that were mentioned earlier on the coordination, on legislation, on value added, on the value chain and minimum environmental protection standards that could be imposed on businesses. These are some of the things that can be developed through this platform, or to which this platform could at least contribute to. Thank you.
Thank you very much, Tigran Karapetyan, for presenting this project and these ideas. And I invite everybody again now on the panel to share a final round of reflections, particularly now having heard each other. From the audience, there were no specific questions so far, but you, of course, the audience or other participants are also free to take the floor. There were technical suggestions, and also I want to apologize again for having given the impression that I cut short only one person, and that was Laura Kurze. It was certainly not my intention. I had misunderstood. I had understood you had made your last point, and I will make sure that you can make up for this also now in this final round. As you have, everybody has been quite short now in the last round, and we have limited questions now. I invite you to have 1 to 2 minutes also reflecting, cross-reflecting. You have been doing this all along. Thank you very much. I would start in the same order again, because
maybe Laura first. Maybe Laura first.
That's a good idea. We can mix it all up. Let's have, if you're ready, Laura first, share your reflections. And if you are okay to go 5 minutes over, that would be 2 minutes for everyone. I think that would be nicer than just one. Thank you.
I'll also commit to stick to the time limit this time. No, thanks. That was really, really interesting to hear from everybody else. And I have to apologize a little bit as well, because I'm not as deep into the issues as I would have liked to be, and as deeply familiar with what the Council of Europe's role could be in this context, given my sort of very last minute addition to the panel. But it was very interesting for me also with regard to learning about the institutional landscape in that regard. I did actually want to pick up on one comment that was made in the chat, and that also relates to what I said with regard to the principles-based approach, and that's the one about trade-offs, which I think is an important one when we discuss human rights, the linkages between human rights and environmental issues, and also the way that we operationalize this into due diligence processes, because obviously you can have conflicting goals. I don't want to say that I have an answer to how to solve these every time. I think it depends on the circumstances, on the context. There needs to be a risk and a principles-based approach to assessing these. Then again, I do think that what I was trying to describe as a principles-based approach can help to at least navigate them and perhaps start resolving some of these dilemmas around conflicting goals and trade-offs. There again, I think it's crucial for companies not to do this by themselves, but to involve their stakeholders, to be transparent about it, and to sort of also acknowledge the way that they went about it. But very important point that was raised in the chat, and especially I think important in the context of the topic of today.
Thank you very much, Laura. It was even shorter now. Indeed, that was not a question in the chat, but pointing to the trade-offs. And I would also ask maybe Thorsten Pinkelpunk to say something about this, and maybe also the point that was raised by Hermann Ott, that legal binding elements can also help competitiveness to be fair. And this idea of encouraging companies to go further than they may need. That could be the non-binding part. And maybe that's a way to solve the trade-offs.
Yeah, thanks, Daniel. I was just about to say, because Hermann was asking that, yeah, for sure, companies love clear rules. We want to have clear rules, and we want to have them as international as possible, and therefore international standards would be kind of the thing we really need. So let me put it that way. What my picture would be: a clear frame as international as possible and cross-sectorial, for sure, but detailed out on a sectorial level, where we need to have some sectorial standards to really then go into the details, so to speak. So these would be one of my wishes. Then maybe when it comes to the Council of Europe potential role, look, recalling the letter John Ruggie sent to the German government, we need to think about salient risk, and therefore we need to have a license to prioritize, so to speak, when it comes to risk-based and principle-based approach. So the salient risk, I would say, is a principle, and you see companies do have the issues regarding the linkage of environment and human rights, normally not in Europe. So we do have these issues in countries where we see weak governance. So maybe, and the due diligence of companies is important, is crucial, but it's not enough here. So there we need a kind of political-led initiatives, and maybe that could be Council of Europe, also a role of them, to go there and help to really have a kind of good governance on the first pillar. So that would help, and that is extremely important, because there the due diligence of the private sector comes to a limitation, and therefore clear roles, cross-sectorial, detailed hours, subsectorial, on a sectorial level, sectoral standards, and a political-led initiatives where it's really needed. So that would be based on a salient risk approach, what I would expect. Maybe a positive ending. We do have an alliance ally here. I mean, what is happening in the whole sector of sustainable finance, recalling taxonomy, recalling the green bond, recalling the reporting now done in Europe at least, and also I see this in Russia, I see this in the US, SASB as just an example. This is an ally to this exercise we are doing, discussing here.
Thank you very much, Thorsten Pink-Punk. Yeah, also making links to allies, finance, disclosure policies, reporting, and transparency. Next panelist, Hermann Ott, would you also share your reflections upon all of this? Thank you.
Yes, thanks. Really, really interesting. And I felt encouraged by what Jan Malinowski said about the kind of possibilities to act within the European Social Charter. And also what I heard from Mr. Karapetyan, what's planned. There was a question to me from the German presidency in the chat. I've encouraged COE to take action. Could you share your ideas on the content of a possible COE, Council of Europe instrument? Well, we've had some ideas here. From what I've understood, Mr. Karapetyan said there's a platform planned now. That might be a kind of a basis, but from what I also hear, and what I've said before, I think it would be very important to have a really binding due diligence instrument prepared by the Council of Europe. We've heard so many reasons why it is best placed to actually do that, with all the experience, with a geographical reach, and with this combination or connection nexus between human rights and the environment. So I would really encourage the presidency and the Council of Europe to move forward into this direction. Thanks.
You left your microphone muted.
Thank you very much. Yeah, so many buttons. Thank you, Jan. And Jan Malinowski also as the next one to share your final reflections after Hermann Ott.
Well, from a Council of Europe perspective, I would say that what we need is member state commitment, encouragement, and support, not the opposite, so that the good governance tools and the good democratic governance tools that we have because of the civil society participation and the stakeholder engagement, that they are enabled to do what they are designed to do, and to add what is necessary to that in respect of the environmental dimension, so that the Council of Europe can really deliver the best contribution possible in this context.
Thank you very much. I guess you mean being encouraged as a general term, or you refer to a specific challenge for you? You mean the lack of ratification, broader ratification, particularly the social charter? Or?
I mean that states have to show their commitment in the Council of Europe through their decisions in the Committee of Ministers, through support for the tools that we have, through adopting new tools as necessary. And I take the opportunity, given that I came back to the microphone, to say that I support the idea of environmental rights also contributing to a level playing field across Europe that Herman mentioned. I think it is very important. It is important in the environmental dimension, in every other social rights dimension as well, but it is very important.
Now, thank you very much. Thank you very much for clarification also and for coming back. Our last panelist, Tigran Karapetyan, would you also please share your final reflections with the panel and the audience? Thanks.
Thank you very much. I would like to just react to Professor Ott's comment and say that a platform could serve as a step towards more binding instruments in the future. The idea would be to take it with the participation of the businesses and the states to a binding instrument that would be workable, including with all the details that were also mentioned by Mr. Pinkebank, that could be provided. The expertise could be provided to develop those along the way on that platform, and then there are all the mechanisms within the Council of Europe that could turn that material into standards, into binding standards in the future. And it's very important to take into consideration that circle of interests that was mentioned by Jan earlier, the circle of interests of environment, human rights, and then businesses, and then coming back to actually interest of the business itself. And I think this is this could be a way to highlight that circle and to get this willing participation in creating obligations. Thank you.
Thank you very much. Thank all the panelists, and also in absence the speaker Bettina Rechinger again for this very interesting exchange in this last panel. I think we almost made it even on time. You were very disciplined. And I thank you also for coming along with the technicalities of the Kudo system. It's basically impossible to summarize the richness of the exchange, but I found very good entry points here. The compatibility of binding and non-binding and getting the mix right. You had very good considerations. Is the Council of Europe maybe the right level? Is it a common space for whether human rights standards are very similar and also the economic activities are very intense? But Thorsten Pinkebank has also pointed out that value chains indeed more and more for BASF, that's certainly true, but for many others as well, really across the globe. And sometimes it's very hard, even for a responsible company to help that ensure, and even in any country of the world that it operates. Tigran was pointing to the ideas of improving the tracking and information, and I think that's always the first step, to have a good transparency system that really we know what we are talking about and where the problems are. Buy-ins from the member states, not only in the Council of Europe, but more largely, Jan Malinowski was pointing to that, and ways to overcome the trade-offs, as Laura Kurze has pointed out. One thought I think is coming back to the global level beyond the Council of Europe. I mean, the Council of Europe and its member states is also interacting in the global arena. And yes, we are in a global crisis, COVID crisis, climate crisis, biodiversity crisis. Many countries now face economic crises, also due to the COVID pandemic. But there are also encouraging signs of international solidarity and cooperation. So the climate change regime, where we just have one party now having come back on the table, giving new momentum to really seriously make these problems not in silos, but have it across the across the board, seeing all ministries speaking to that this is climate change is a topic across the board, and that's the same for all environmental challenges or most. So pushing on the international level for high level standards and then bringing it down to the regional level, and then into the sectors, as Thorsten Pink had pointed, where the devil of the detail sits, and then through standards and working with the countries on the ground, the companies on the ground, are all approaches that I think can be fostered, but where we all sit, each of you particularly. So thank you very much, and thank you again also to the Council of Europe for organizing this, and the German presidency of the steering committee. That was very interesting, and I'm looking forward to any further follow-ups on this event and other events. And maybe some of the panelists are now encouraged to be in contact with each other and maybe publish a paper or write a policy guideline that can make it to be adopted one day and advance us. Thank you very much. Thanks to all panelists for bearing with me.
Yes. Thank you very much to the participants of this last panel. And now it's time to conclude this workshop. I will do so with pleasure, and the pleasure is all the greater that we are doing it from the Council of Europe main building, as you noticed already. So despite the fact that our corridors are emptier than usual, so we are still remain operational, and we have some 10 people in this room, so which reminds us of the good older days when we used to get together for such events. But the online mode of event was not detrimental to its quality. So it is, of course, impossible for me to make sound conclusions within 5 minutes, which I still have at my disposal. But I would like to start by taking the opportunity to thank German presidency once again for their decision to include this important topic in their presidency agenda and to give it a priority. It was a very timely event. Many of the participants mentioned already the conference which was held by another presidency of the Committee of Ministers in the Council of Europe, which was Georgia's conference held 1 year ago, which provided a kind of roadmap for the Council of Europe action in the field of environment and human rights. And one of the starting points of this roadmap was that the Council of Europe, as the guarantor of our common pan-European legal space, has a key role to play in mainstreaming the environmental dimension into human rights and pursue a rights-based approach to environmental protection. So with this starting point in mind, the declaration provided different lines of action of the Council of Europe, and today it was a particularly good moment to have another look at those proposals which were contained in this declaration, which is still of great current interest, but also to have a look at some actions which have been taken in the meantime. So we are not only speaking today about next steps, but we also think of what has been done within this very difficult year. And it's interesting to note that there is progress in line with the proposals which were made at the time. So, of course, it is the foremost focus of the declaration was on the standard-setting activities, and many participants mentioned today the need to upgrade European standards, and not only upgrade European standards within the Council of Europe, but also try to make them applicable beyond the European states. European Convention on Human Rights and Social Charter are, of course, in the center of our activities, whatever the area of these activities. Is not the exception when we speak about environment and human rights and business and human rights. And of course, we have also other standards which have been mentioned today beyond our main instruments, which are Social Charter and European Convention of Human Rights. The Convention on Criminal Responsibility for Environmental Crime of 1998 was mentioned, and you know that there is a plan to upgrade these standards within the Council of Europe. We have another convention which deals with civil liability for damage resulting from activities dangerous to the environment. And we have a very important development we witnessed during this year, which is entry into force of our Tromsø Convention on access to official documents, which could guarantee public scrutiny on decision-making also on environmental issues. So this convention echoes, of course, the universal instrument at the UN level, which is our Rus Convention of 1998. So this is so much we can say about standards, and the standards are, of course, being developed within the Council of Europe. So tomorrow, as you heard, there will be the first meeting of a drafting group of the Steering Committee for Human Rights, which will deal with a new instrument, recommendation, draft recommendation of the Committee of Ministers on Human Rights and Environment, which will not be a binding instrument, and a lot has been said about the need for new binding instruments at the European level, but we also have some non-binding instruments in the form of recommendations of the Committee of Ministers. You know, we have hundreds of recommendations, which are also very instrumental in promoting common standards on some issues, and including emerging issues. So I think that this year we'll see a tangible progress on the draft recommendation, and perhaps by the end of the year we will see already specific results of this work of the Steering Committee for Human Rights. But the Council of Europe has never limited its action on standard setting. So it is interesting to note that our two other pillars, which is monitoring and cooperation programs, are also very valid when it comes to activities on business and human rights and environment and human rights. And it is interesting to note that some of the ideas which were aired 1 year ago at the time of the Georgian presidency of the Committee of Ministers have been implemented within this year. And I would like to mention two tangible steps which have been made within our Pan-European HELP program, which is a program for human rights education for legal professionals. So two new courses have seen the light of the day since 1 year. So one is Environment and Human Rights, which is now available on HELP platform. The course addresses the European and international frameworks and practical approaches that will support legal professionals and other professionals in understanding the connections between human rights and the environment, and in particular how to apply the human rights-based approach in environmental protection. And during this year, another important course on business and human rights has been upgraded and updated, and it is also available today on our Council of Europe platform, readily accessible by anyone in Europe, absolutely free of charge. And today, this course on business and human rights, we consider it to be an important vehicle to apply standards regarding business and human rights, and in particular, Committee of Ministers' recommendation on this topic, which was also mentioned on numerous occasions today. So this business and human rights course addresses legal frameworks, methodologies, and practical actions on how states corporate actors and legal professionals can prevent, mitigate, and remedy potential and actual corporate-related human rights abuses. And these are only two examples which bring me once again to thank the German authorities, because both activities were conducted with the support of German authorities and with support of German voluntary contribution. So it was, by the way, Germany and Netherlands who provided some voluntary contribution to support these activities of the Council of Europe. And this is a bright example of how even a small contribution could be instrumental in promoting our standard in practice, because it is, of course, very important to create new standards. And there are bright ideas also about possible protocols and conventions. But, of course, we need also to act very actively to implement the existing standards. And what is great about our cooperation activities is also that our cooperation activities on the ground enrich our standard setting processes, and this synergy between cooperation projects and standard setting activities in the Council of Europe, something which is unique and is considered to be added value of this organization. So I will not speak more about other cooperation activities which are being planned. So Tigran mentioned some of them, but there are other projects. So we have draft projects which are on our desk, but we need support of our member states in the form of contributions, both financial but also in kind. And we also need support of businesses, because we think that in this area, business enterprises could be very, very helpful in joining the project activities, and we are looking forward to their participation in the near future. And I think that in the coming month, we will see more cooperation projects with different member states and private entities also, in order to ensure the implementation of our standards at the domestic level. So we have different actions which I will not enumerate, but of course it includes the implementation of legislative and regulatory framework at the national level, because we are speaking about European level, but of course there are also rules to be applied at the national level, and the effectiveness of the implementation is something which is also promoted by cooperation projects of the Council of Europe. It also, of course, includes strengthening capacity of relevant national, regional, local authorities to apply the standards in practice. It also enhances procedural rights, also education, public awareness about the issues, and of course we share through our cooperation activities promising practices, which also is a very important tool today for the Council of Europe. Right. So much about the synergy of different lines of action within the Council of Europe. So I would like with this to conclude, and of course to wish very good luck to our drafting group, which will start its work tomorrow. So DHINF, I'm sure we will see very, very promising results in the months to come. And I would like also to thank the whole team who has been working on this event, both in Germany, so our German partners, but of course all my colleagues within the department who have prepared this event since some time, and which I think personally have made it a success, which is nowadays very often unpredictable because of possible technical problems, but it gives me an occasion also to thank wholeheartedly all the technical team who has worked in this room since this morning and even before to prepare this event. And I would like also to thank very much interpreters. I see a team of interpreters also with us, and it was very, very helpful, especially taking into account the problem to interpret online debate. So thank you, and let's keep in touch on the next steps.
Thank you very much, Mikhail. Unless our German colleagues wish to take the floor and make their final remarks, we would close the session now. I'm just taking a look at the request list to make sure that there is no request from our German colleagues. So with that, I think we can close this workshop. I thank every speaker and panelist for their interventions. Thank you also to the participants in the session who have been observing and following the session and putting very interesting questions. So bon appetit to everyone, and hopefully we'll meet in similar workshops and discussions. Thank you and goodbye.